Hi viewers, welcome to my YouTube channel at Newsworthy Publications. My name is Ben Gray, an amateur journalist living here in Bristol, where I lived for the last 20 years. This is another documentary. This one is entitled Judge Michael Longman, Evil Incarnate. Judge Michael Longman is I think still sitting as a judge in Bristol Crown Court. And this is another another documentary setting out yet another judge who happens to be, or originally was from Albion Chambers. As I've made clear in my other documentaries, there is a Albion Chambers-centred conspiracy against me, Ben Gray, in which pretty much any case against me is spearheaded by Albion Chambers or with very close connections to that Chambers. So without further ado, let me recount the ordeals I suffered at the hands of this monster, Michael Longman, and obviously you can judge for yourself the extent of venality and criminality that this judge is engaged in. This account begins at about 2:15 p.m. on the 25th of July 2009, where I was a job seeker who had to sign on at the Bedminster Job Centre, which is about 10-12 miles from where I live in East Bristol. I was having to sign on there because my local job centre, which is literally almost on my doorstep, were attacking me. There was evidence of security guards attacking me with full collusion of the local police. The matters had been, some of these attacks had been resulted in my arrest, being tortured and strangled at Bristol, at Trinity Road Police Station, which thankfully I noticed no longer exists, but very much existed in 2008-2009 time period. To avoid any further confrontations, any further kidnappings at the hands of the police, with full collusion of the judiciary, certainly Mr Justice Macduff, which I will come to in another documentary, those ordeals. But whatever the circumstances, I had to, it was clearly in my best interest to go to Bedminster Job Centre, as I say, quite a considerable distance from where I lived. So I attended this job centre to sign on the 25th of July. Whilst I was there waiting for my appointment to take place, I was approached by two security guards who took exception to the fact that I was sitting down at a desk where there was no member of staff sort of at the other side of the desk, and I had a bad knee, so there was no other seating available, and that area of the building was pretty much empty. So I thought, no great harm would come to my sitting on an empty chair at an empty desk, waiting for my appointment. And as I was sitting there, I was approached by two security guards, one by the name of Andrew Petch and the other by the name of Kevin Ryan. And they ordered me to stand up. They said that I wasn't permitted to sit at the chair in question. And I was trying to point out that I had a bad knee, that there was no other seating available. And whilst I was remonstrating with them on what was clearly a ridiculously petty matter, really to do with pecking order, because it was simply the fact that obviously what they objected to was the fact that I was not sitting in the correct seat, as opposed to a seat that sort of presumably gave me a little bit more status, which the security staff and the staff generally at job centres take very, very seriously indeed. They do like their status. They have the security guards, who are pretty much, many of whom have criminal convictions, and they of course are superior to the job seekers, and then we have obviously all the hierarchy all the way up to effectively the head of DWP in London. But anyway, that was presumably their objection. But I was simply trying to point out about my bad knee. And as I was doing this, I was approached by a huge male by the name of Philip Walters. Now, Philip Walters was another job seeker, was another client like me. He decided that it was his business, not the security guard's business, to take exception to the fact that I was now complaining about something which by any accounts was not causing anybody any distress at all, by sitting quietly at an empty desk waiting for my job seeker review. And I said it was none of his business, and it was quite shocking because he was right in my face. He was behind me initially, so I turned around to be confronted by this huge male looming over me, and taking. And when I told him it was none of his business, within a few seconds he reached out, he grabbed me by the throat, pushed me, spun me round, pushed me against chairs that were behind me, and pushed me double. So, and as I was being pushed backwards against the chairs, I tried to grab hold of something to keep me from totally falling onto the chairs, and I smashed my part of my wrist area on a corner of the wall, causing me even more pain. And this man held me there, throttling me for a good 30 seconds, bellowing into my face about, I can't remember why he attacked me in the first place or what his complaint was. Then he eventually let go. He caused some of the people that were sitting on the chairs to, including an elderly lady, to scuttle away in terror of this violence. And I myself moved away from him and complained to the security guards that this man was completely lunatic. And the guards, which then caused Mr. Walters to chase after me across the job centre to another area of the job centre. And Philip, in particular, security guard Kevin Ryan, came to attack me. He accused me of being the instigator, and Mr. Petch had to meanwhile went after Mr. Ryan. Mr. Walters, and at one point, Mr. Walters clearly looked like he was going to attack me again, so I picked up a chair and I held it as a buffer between me and him, and was clearly having to use it if he was going to actually physically lay hold of me again. But thankfully, Mr. Petch approached Mr. Walters and said, escorted him back to the corner of the area of the job centre we had originally first encountered. But Mr. Ryan still pursued me, and he at one stage he actually grabbed hold of my tie and attempted to pull me away from where I'd hidden behind or avoided Mr. Walters, and was now avoiding Mr. Ryan behind another empty desk area of where I had been pursued by Walters. And he literally tried to pull me away from that area as if I was a dog on a lead. And I resisted that. He let go of my tie, and then went over and got my bag. And in order to try and get me out of the job centre, he then grabbed my bag and threw the bag out of the job centre where I was supposed to go after it. And then obviously that was his way of getting me. He was now trying to eject me from the job centre without having had my job interview, for having done nothing except be attacked by Mr. Walters. The CCTV, yet again, this is the umpteenth situation. If you go to my other videos, Barbarians at the Gate, you will see chunks of CCTV that were missing. I was tortured with the use of handcuffs during another incident. The CCTV was missing or claimed to be inoperative, but effectively was missing in that case. This is a very repeated example, and indeed there was more footage later because I was arrested later that day, and CCTV from that incident. There was a further incident at the police station, So the point I'm coming to is that there were two sets of CCTV. The CCTV that I'm about to play in a moment captures some of the aftermath after Mr. Walters had chased me to the other part of the job centre, and where I picked up the chair, and the original incident was also captured on CCTV because there was a CCTV camera for that era as well. But that CCTV was never disclosed. There was conflicting information during various trials as to whether that CCTV camera worked. or was available. The long and the short of it is the only footage available is the footage I'm about to show you. And so the original incident was I've had to rely on witness statements in support of my allegations, or to show contradictions in various statements from different individuals. So I'll shut up. I'll show you the footage, and then I'll come back to the documentary. So there you have the incident, the aftermath of the incident. Clearly, Mr. Walters, whatever he has done earlier, and of course we'll come on to further evidence to support my allegation that he strangled me and obviously caused me considerable pain and terror. But whatever's happened there, you can see I'm moving away from him, and he is pursuing me, and you can see how massive he is, and you can see that he's clearly irate. And I pick up the chair very momentarily. I don't throw it at anybody, as Mr. Ryan was later to allege in sworn statements. I simply use it as a buffer, and obviously as a threat to Mr. Walters, that if he carries on, he's going to be walloped with the chair. But of course, as soon as Walters is led away by Petch, I put the chair down, but I'm now being pursued by Mr. Ryan. And then you can see Mr. Ryan. I think you can see the bit where he's grabbing my tie. I haven't viewed it myself for some time, but then you can certainly see him grabbing my bag and throwing it out into the, or going to the main entrance and throwing it out into the street. So within about 5 or 6 minutes of this incident occurring, the police turn up. We have a PC Bethany Feven in particular, who was the one of the female officers who was sort of alternating between talking to me and talking to Walters and talking to the security staff. And they threatened me with arrest if I did not leave the job centre. I don't believe there's any powers they can do that. That there was no evidence that I was creating a breach of the peace, for instance, in front of them. There was the position was that I was entirely to blame for what had occurred between myself and Walters, and then with the security staff, and that it was me that would have to leave the premises. And Walters was being treated officially as the victim. I complained, of course, that I was the victim of assaults, and I obviously had the injury to my wrist. And the entire incident should have been or was filmed by CCTV, but there was no interest in looking at the footage by PC Bevan or others. The only issue was that in order to avoid arrest of myself, I had to leave, and I refused to leave, and I was handcuffed, rear stacked, so that the handcuffs were placed way too tightly. This is another modus operandi of the Avon Somerset police officers, is that they put the cuffs on tortuously, especially if that I'm creating problems for them in terms of paperwork and potentially kidnapping, evidence that they're kidnapping me and so forth. Again, you can see other video documentaries where they've done the same thing, and indeed one of their other methods is, even when I've got injuries to my wrist caused by civilians or other parties, they will put the metal handcuffs too tightly onto those very injuries that I've just received from the from an earlier incident, which is what they did in this case. So they put the cuffs on rear stack, which is my arms behind my back. They put them at an awkward angle. Then they made me sit in a police car so that the angle of where I was sitting impacted on the, increased the amount of pain that the handcuffs were causing already because of the awkward angle of them. And I was taken to Southmead Police Station. And I'll come on to what obviously happened at the station in due course. But at this point, I've clearly been kidnapped. There's no question that I had done nothing wrong. That all the evidence pointed to me being attacked by Walters. The footage clearly bears this out that you've just seen. And I'll, without going on, I'll just read a bit of a statement from PC Fevlin's justification for arresting me. I spoke to a second security guard, and he stated that the males had been fighting and that the male wearing a tie had picked up a chair and thrown it. Gray was the main aggressor. I believe that she's reporting what Mr. Kevin Ryan has told her. So that's clearly fabricated testimony. I wasn't. There's no suggestion that I was being aggressive during the incident when the police turned up. So that they could have taken a few minutes to look at the footage and find out, rather than rely on the testimony, which is what they always do, even when there's available CCTV footage, is to just rely on the testimony, arrest me, and then months or years later either discontinue the allegation, or in this case, although I was never formally prosecuted for anything to do with this incident, there was a later incident which did lead to my being prosecuted and going in front of Judge Michael Longman, and being prosecuted by David Chidgey, who'd also successfully prosecuted me in another matter, and we'll come on to that in due course. What happened later was that I was booked in by a PC booker. Unfortunately, I can't locate his first name, but Police Sergeant Booker, who was the custody sergeant who put me in. I was taken to a police cell which was covered in urine. It stunk to high heaven, or to high hell, whichever way you want to describe it. And I complained about that, and I complained about the circumstances of my arrest. And I got into an argument with Booker, and at one point I threw some water. I had a cup of water, drinking water that I'd been given by the police, and I threw it at the officer, and they slammed the door. He shut the door, left me there for about 5 or 10 minutes, and then he ordered some officers whose names I never obtained and never received to enter my cell or the cell and truss me up. Put me back into handcuffs. So I'd now received further injuries from the handcuffs that had been applied by Fevin and others at the job centre, and the injury from Walters, and now handcuffs again being put on the injuries of the injuries on my wrists, rear stack, and then my legs were bound up, and I was forced to lie face down on the floor while a PC, Katie Marr, I believe her name is, Maher, supervised me whilst I was left to lie face down in a stinking police cell, all because of a splash of water on a police officer. And eventually I needed to use the toilet. I was forbidden from having the straps removed, and I had to urinate myself in my trousers in front of a female police officer and one of her colleagues, because they refused to allow me to be unrestrained in order to go to the toilet. It was accepted that the water was the water being thrown. It was just water. The Booker claimed that he originally thought it was urine, although where I would have got the urine from in the short time it took for us to have an argument, it was clearly I wouldn't be standing there in the normal course of events with a cup of urine and so forth. But in any event, he accepted it was water. And just to back up the issue of restraints, we do have a statement from PC Katie Marr in which she stated, I went to Gray's cell and saw that he was handcuffed in the rear stack position and limb restraints were placed underneath his knees and on his feet. Oh yes, and during the initial struggle when the restraints were being placed on me, I had an injury to my knee, which had resulted in a scab. The scab was knocked off, so I was also covered in blood and urine during my restraints in the cell. Then I'm eventually released from the restraints, and I'm interviewed by PC Mar as to the incident. I was accused of a fray. That was the original reason I was brought into custody and or arrested, involving the incident between myself and Mr. Walters. Now, of course, if I had committed an affray, if the police genuinely believed there had been an affray, well, first of all, you would have, as again, they would have reviewed the CCTV immediately, and certainly had that present in the interview, which they didn't have. Secondly, of course, they wouldn't have asked me to leave if I'd just been guilty of an affray. An affray usually involves two people. It's the person you're fighting with. So Walters was just as guilty if there was an affray as me. They wouldn't have asked me to leave and then go about my business, which was the original reason they arrested me, was for refusing to leave the job centre. Again, that's evidence that the police knew there had been no affray, certainly on my part. And then you can see from the latest statement from Miss Marr, she doesn't provide any evidence about what's happened at the interview, about my allegation that I was the victim of strangulation by Walters. And of course, his violent assault against me obviously terrified all the other members of the job centre. And there's no mention of my counter allegations, which was in any event backed up by CCTV footage, and indeed a further statement, as we'll come to, from a Miss Elizabeth Evans, who was actually a member of staff from the job centre itself. And she concentrates her statement only on the incident between myself and Booker. I was then charged originally not with anything to do with any incident at the job centre, but for allegedly assaulting Booker with the water. That was discontinued later. The police and the CPS justified the discontinuance on the lack of availability of CCTV footage. Which obviously was preposterous. How could the CCTV camera is actually inside the cell itself, and it's there obviously to protect the safety of the person in the cell and the police, and of course clear up any false allegations. So as we'll come to, that's now two lots of CCTV just in this one incident that has conveniently not been available. Obviously they didn't want to show the CCTV of the incident in the cell, not because it didn't show me throwing water at Booker. Booker was already half out of the door when the water was thrown at him. There was only a small amount in the cup, and so if anything, he got a tiny splash of liquid from my cup onto himself, if any. And of course, no water would cause any injury, even if it had been a whole cupful. But obviously they didn't want to show me being trussed up and forced to urinate myself with the blood ripped off the bloody injury caused by having the scab ripped off my leg when I was being trussed up again like a turkey for Christmas by the officers who were involved in that incident. And they obviously didn't want it. Despite the fact that the CPS know that they have these evil crony judges like Michael Longman on the bench who will collude in any form of perjury or torture or kidnapping, as we can see from this case, there are some limits, obviously, which obviously included having the footage which I could have then placed online and so forth. So those actual charges were discontinued. And then there was an ongoing, of course, investigation into the affray allegation concerning Walters and the staff at the job centre. So eventually I got disclosure of the material surrounding the incident on the 24th of July 2009. And that included a statement, as I mentioned just earlier, from Elizabeth Mary Evans. And Miss Evans, I think, was one of the job centre staff who was behind the desk who had left the desk where I had gone to hide from Walters after I picked up the chair. But in any event, she gave a sworn witness statement in relation to the incident of the 24th of July, in which she stated, I could see at the back of the centre, at the seat in the seating area, one male who I did not know had hold of another male I knew to be Ben Gray by his throat. He did this by holding him with his right arm. I could hear the male, Walters, calling Gray a nutter. So this incident was, so my allegation that was given to Ma and then whitewashed by Ma in her statement to later statement about what happened at the interview with her was quite clearly borne out. I had an independent witness. I mean, she wasn't actually an independent witness. She was part of the job centre staff, but she obviously had enough credibility, enough decency and integrity to actually give a truthful account of the assault from Walters. And of course, apparently Walters is strangling me because he thinks I'm mentally unwell, which of course makes his attack even more unconscionable and wicked. So, in spite of so again, this is obviously because my evidence was borne out by an independent witness, by Miss Evans. That, of course, was further justification or further reason for the police not to seize and/or the staff not to provide the CCTV that proved my original allegation. Certainly, I gave the allegation when the police turned up at the job centre itself, and then I gave the allegation formally in witness statement to Ma, and then there was Miss Evans' statement, all of which would have been backed up to the hilt by the CCTV, but obviously that was clearly not going to happen because the CCTV was like the CCTV at the cell later in the day, suppressed because it proved that I'd been the victim of a violent attack, just as I had been later tortured and violently assaulted by the police in the cell. So the later allegation in terms of the assault by the police collusion in the various assaults that occurred on the 25th of July, we have an Inspector Chambers investigated those allegations in case reference CO 67009. And the only position that the only part of the statement that I can fathom is sort of actually relates to my complaint is about the missing CCTV. And the Chambers states in his formal findings, I consider job centre staff to be reliable witnesses and accept that they, Messieurs Ryan and Petch, say this camera was broken or not recording. It formed no part of any decision to arrest. I mean, what? I mean, that's gibberish. I wasn't claiming that it shouldn't have formed part of the decision to arrest. Of course, they could have viewed some of the footage because it was available, because we've seen it. That was in the other part of the job centre. So the only issue was whether they, in any event, they had an independent witness that had seen me being strangled. And so obviously Ryan and Povey's statement was utter fabrication, that I had been the instigator of an assault. And of course, we've seen me pick up the chair, but I don't throw it. I'm only picking it up as a buffer between myself and Walters, who's about to attack me. Ryan gave a clear-cut statement that he had claimed that he'd seen me throw the chair at people in relation to the incident. So Mr. Ryan's statement, sworn statement of the 25th on the 24th of July 2009, bears reading out in full. The statement, of course, as all sworn witness statements to the police are under, I think it's Section 9 of some act or other. They're called Section 9 statements. The statement has to be true and to the best of their knowledge and belief, and make it knowing that if the statement is tendered in evidence, I shall be liable to prosecution if I have willfully stated anything in it which I know to be false and all do not believe to be true. So the statement was tendered in evidence because it became part of proceedings in front of Judge Longman, as we shall come to. So Ryan states as follows: I am the above named person and I reside at the address Overleaf. I am making the statement in relation to another I witnessed at my place of work, job centre. I can't read some of the writing because it's written in hand, but something in relation to, I think it's to another, But in any event, Job Centre, Kent Street, Bedminster, Bristol. At approximately 14:10 hours on Friday, the 24th of July, 2009, I was working as a security guard at the job centre when I saw a male I know to be Gray, whose first name I do not know, take a chair towards the back of the centre and sit on it. I approached Gray and told him that he couldn't use the chair on it as it was there to conduct interviews. Gray responded aggressively saying, "I am entitled to a seat. Can you get another one?" So he's obviated the fact, or missed out the point about my bad knee, which obviously I would have mentioned, and I could have had medical evidence to prove it if it was ever sought. I told Gray that I would get him another seat, and he then shouted, making comments about spending millions of pounds on the war while getting up out of his seat. I turned my back to Gray and I went to put the seat back next to the desk. Within a few seconds, I turned around and I could see in the waiting area that Gray and another male I didn't know had hold of each other. They were holding each other by their clothing. So this is the clear-cut fabrication. We have the not only my evidence given to PC Mar, and of course when I gave her the statement later that day, I couldn't possibly have known that they were so corrupt that they wouldn't go to I couldn't have known that the CCTV wasn't available, wouldn't be working, or anything along those lines. I couldn't have known that Miss Evans would back up my version of events. I didn't have hold of Walters at all, and Walters didn't have hold of my clothing. He had me throttled round the neck. The other male, which is Walters, was clearly angry, and Gray seemed to be goading the other male on, saying words to the effect of, "You're grabbing me." I don't know how that's goading. If I did say it, I said it was a simple statement of fact. He had grabbed me. I cannot recall exactly what was said. With this, the other security guard, Andy Petch, came to join me, and we approached them and separated them by standing between the two. As soon as we did this, they loosened their grip on each other. I told Gray to move away to the other side of the building. He took a few steps away and started shouting to the other male, "You're fucking crazy, you psycho." He was rotating his finger pointed at his head in the crazy something, again seeming as if he was goading the other male to a fight. The other male then pushed past Andy Petch, so clearly an assault there, and something to get to Gray. And I think I went to get Gray or something like that. I do not recall him saying anything. As he did this, Gray then picked a chair up next to one of the desks and threw the chair towards the male. By this stage, they were only a few feet from each other, and it hit him in the waist and upper leg. Well, you can see I didn't throw the chair, and it makes no contact with it. If there's any contact, that's because Walters is attacking me. He's already on top of me by the time the chair is lifted, or virtually on top of me, and he's coming towards me, which of course is again lied about by Ryan. Andy then stepped the other male. So Andy then stopped the other male, or stepped the other male, and Gray ran behind the desks. He pushed past me in order to do this. He was still shouting, but I cannot recall what he said. Andy was ushering the other male away from Gray. Gray then picked up one of the metal bins next to a desk. I approached him and said, "Put it down." I can't remember picking up a bin. We got the footage and we can look at it again to see whether I do that. Gray responded, "You can't hold me here with this bloke after me." He put the bin down and he started walking towards me. I put my hands up and said, "Calm down," and I thought he might hit me. Gray then pushed past me again and shouted, saying, "You ain't going to stop me." I don't use words like "ain't." My elocution is standard English. I wouldn't say "ain't." So not that it matters that much, but I didn't say anything along those lines anyway. And he looked still aggressive. I said, "Get out." After Gray saying he wouldn't leave, I picked his bag up off the floor and said, "Get out." I said to Gray, "You wanted to get away from this bloke, so go." Gray didn't leave and said, "Well, there's still the issue of my having to sign on. I'm not there voluntarily. I'm not there because I like being in the Bedminster Job Centre. I have to be there to make my have the interview in order to receive benefits." So he's actually trying to deprive me of benefits by ordering me to leave a building in which I have been attacked from start to finish. You wanted to get away from this bloke, so go. Gray didn't leave and said, "I'm the one that's been assaulted and you're trying to throw me out. You're a thug." There's no mention so far of him grabbing the bag, but we'll see. I said to Gray, "Get over to the other side of the office," and painted him away or something like that. Something illegible. Gray started saying to me, "I'm going to have you in court. You assaulted me." I worked away to try and diffuse the situation and let Andy deal with him. A short time later, the police arrived. I would describe Gray, etc., etc. He concludes by saying, "I would describe Gray's behaviour as strange, aggressive, and was initiating the trouble. The other male was to start with fine, but angry when they were bostling, hassling, God knows what that is. He calmed down soon, and they were apart, unlike Gray." Well, it's obviously every single line of that. I will just finish off the statement. At approximately 1500 hours, I copied CCTV footage from the job centre 24/7/09, which I handed to PC Gaunt. So they've got the footage of the same day. Presumably that was, as was later claimed, only the footage of the second part of the incident, i.e. When I've had to pick up the chair to defend myself from Walters. He doesn't make it clear whether which parts of the footage he's downloaded and given to the police, to PC Gaunt. But of course, he says I initiated the incident. He claims not to have seen anything. If you remember the first part of his statement, he says that he looked away and that suddenly he turned around. He didn't hear anything. He didn't see anything. We're only that actual area of the Bedminster Job Centre is only a few square meters, so there's hardly any space anyway to swing a cat. So the idea that two large male, Mr. Walters and myself, would have got to the stage where even if we go by Ryan's testimony, that we've grabbed each other's clothes, he would have heard what was being said. He would have had to clearly had it. Bearing in mind his initial position was that he was talking to me. I was engaging with Ryan himself before Walters became involved, and Ryan is claiming that he didn't see anything as to how I got involved with Mr. Walters, to the extent that we had grabbed hold of each other's clothes. So if his testimony is true, which it clearly isn't, he clearly was witnessing close hand everything that went on between myself and Mr. Walters. But even if what he's saying is true in the first part of his statement, then how could he possibly say that it was all my fault and that I was the one who initiated the incident when in the subsequent part of his statement? And all of that is, of course, to detract away from the utter fabrication about me being strangled, because obviously I didn't grab hold of his clothes. There's no statement from Miss Evans to that effect, but Ryan was seen by an independent witness as grabbing me round the throat, which was my allegation to the police when they turned up, and then an interview. So Ryan is lying, and lie upon lie upon lie, and not as Inspector Chambers, who is himself the chronic liar, an honest and credible witness. Indeed, he himself has assaulted me several times, because he's then piled in on top of me after knowing that I'd already been assaulted by Walters to begin with. I've done nothing wrong at all. The only fault that I have committed is committing the unpardonable sin of sitting in an empty chair at an empty desk. And then just complaining about the fact that I had a bad knee, which was why I needed somewhere to sit. This minor, trivial little incident over a chair, which is clearly them just simply victimizing me. You would have thought their security staff, they're not really supposed to be dealing with, exactly where people are seated at any one time. But you know, that's the extent of my wrongdoing. I do not attack Walters. He attacks me. He calls me a nutter. He's got me round the throat. And then I naturally respond to his attack by saying he's the nutter. So it's all right for him to call me a nutter, but then I'm goading him when I reciprocate, and I've got the evidence that he's clearly not stable by the violence that he's carried out on me, which is a strangulation, which is clearly a serious assault. And then I'm attacked by Povey, and you can see what his conduct is. Whatever he says happens and then he accuses me of throwing chairs at people, which of course is again further fabrication. And so this matter was eventually discontinued. I'll show you some of the diagrams of the injuries. I'm sure you can, you're not going to dispute that after the sort of violence I've been subjected to now on 3 or 4 occasions, I've been attacked by Walters, then I've been attacked by Povey, then I've been arrested first and shackled, and then I was shackled again. So 4 separate violent assaults from various individuals, from Walters, Ryan. And Petch was fairly civilized compared to everybody else involved in that incident. And of course, as I pointed out, many other job centre users were as much victims of the affray situation or the violent situation caused by Ryan and Walters, as you can see from the footage. So, and there are just some of the injuries to my wrist that are recorded, and of course, in terms of the scabbing knocked off my knee and the bloody injuries received then. But of course, I can't get legal representation under any circumstances. They all take their orders from Albion Chambers. The solicitors, Albion Chambers, are the go-to barristers and judges, and they're all from the same chambers in court anyway. But I'm unrepresented. I've still got evidence of there's been perverting justice, because of course, if the footage concealing the commission of an offence, and I'll put the common law authority up on the screen now, but of course, concealing the commission of an offence by getting rid of or suppressing evidence of a serious violent offence is itself a serious criminal offence. And because I'm representing myself, I've gone back to the job centre, although I'm supposedly banned. At some point I've received a letter from a solicitor. I should be able to find it on screen, and if I can, I'll find it on my files, and if I can, I'll put it up. Whichever firm it was, they sent a letter saying that I was now formally banned, and if I continued to attend the job centre, I would be subject to some sort of civil proceedings in terms of obtaining an injunction against me. But it had no bearing at all. It wasn't a formal court order. It was anything but a threatening letter from solicitors, and we get those because they've been paid a chunk of money from the government, effectively government money. And of course, I'm accused of the same things that the solicitor simply rattles off the allegations made by Ryan without any reference to any kind of proceedings or any other side of the events, or certainly not evidence from Miss Evans or the CCTV, etc. So I took the letter as a pinch of salt, which is as having no legal binding at all, and I attended the job centre on the 3rd of August with a camera in order to, first of all, record any evidence of assaults against me if that was to transpire, bearing in mind I'm not subject to any bail conditions or any court order, as I've said, and obviously to record the position of the camera, which the police are now saying doesn't, they either can't find or doesn't exist, etc. So I wanted to gather evidence for any future proceedings involving against me or against the DWP or against the police for false imprisonment and kidnapping, which is clearly what they've done, and assault and torture, to validate the evidence of the camera being in the exact position where I say Walters originally started to throttle me. But I'm prevented from getting in. The doorway is blocked, and there's now Petch, I don't think, was involved in this incident. There is now a very large black security guard called Birchall Dick. We've got Ryan again, and there's another Paul Povey, who's another security guard fellow, and then there's so these 3 security staff are now using violence to keep me from even entering the job centre at all. They've got no authority to keep me from the job centre. The issue of my trespassing or being on the property that belongs to the government effectively, so I would have thought it belongs to the people anyway. But in any event, it's a civil matter, and they're using violence in a doorway where, as you can see, and I'll show you what footage I have. Unfortunately, what's happened is that I lost the original DVD that the incident came on, but I did, during the course of proceedings involving this incident, I was later prosecuted, as you'll find out. I did record some of that onto my own camera. My camera didn't have very good high quality, so unfortunately it's very poor resolution footage that you'll see, but you'll get a general gist of this sort of violence that we're talking about. And you can see that the violence that's been handed out to me, I'm being shoved against railings, I'm being pushed down into so it's a ramp that leads up to the front door. So I'm being pushed against railings, pushed down the ramp, all of which is going on whilst individual members of the public are trying to access the job centre in and out of the job centre, and they're just carrying on. These people are obviously put in harm's way by the fight that's going on between myself and the security staff. Meanwhile, there's a Ruth Lisi, who's the manager of the security, who's ordered the security guards to attack me effectively. Will come out, will obviously look at her evidence in due course. But you can see the back of her head, and obviously I'll give you a little arrow to show who Ruth Lisi is. She's the manager who's literally acting like an empress in the Colosseum, and she's watching this violence that she's instigated unfold. It's totally unnecessary. I've got a camera, so unfortunately, in my stupidity and haste, and because of the nervousness surrounding the situation, I either didn't put it on or it didn't work, and I didn't realize it wasn't working, so I wasn't able to record any of the altercation on my own camera. I think I did also have a dictaphone playing, though, so that this caught the sound quality of the sounds that going on between myself and the security staff. But we have the CCTV that's pointed sort of a bird's eye view down at the doorway, so everything is recorded minute by minute, and that's the footage that I've got. As I say, it's a very poor quality because of it's a recording of a recording on a not very good digital camera to begin with. But obviously, what then unfolds, we can look into. So I had this altercation. Eventually, they sealed the doors, which is obviously what they should have done in the first place if they wanted to prevent me getting in. And I'd called the police well in advance. I said there's likely to be some sort of public order incident. I explained this all. The police, of course, didn't turn up because of what they do. This is another one of the never mind. It's one of the usual ways of stirring up trouble is that they stay away from any public order. That I've got this reputation, obviously by now, of getting into altercations with security staff in various buildings, which they then stir up by not being present to diffuse any situation and ensure that there's no public order incident and that everybody's safe, not just me, not just the security guards, but obviously the poor innocent bystanders who want to get in and out of the job centre and so forth, so that they stay away from the incident until it flames up into something that they can then bring against me, even if it's complete perjury. They're just hoping that the general mayhem and the confusion of everything will give them some kind of prima facie case against me. And of course, waiting in the wings, as it were, are people like Judge Longman and Judge Picton and all the rest of the gang from Albion Chambers, just rubbing their hands, waiting to get their hands on me to get a bit of vengeance for the cases that I've won against them, and of course the allegations I'm making against them, that they are a bunch of gangster crooks who themselves should be behind bars. So this is where we've got to. I've once the doors are sealed, I can't go any further at that stage, so I simply leave and go home. And on my way home, I'm called by the police, and they're saying that they're after me and that I should hand myself in. And I say, well, I've done nothing wrong. I'm the victim. And later that evening, bang, 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 bang on my door. And there's a PC DaCosta, Earl DaCosta, who's sort of the ringleader of all this. And I'm arrested. I'm handcuffed, at least front stack, which is something, I suppose, and taken to Broadbury Road Police Station, so not Southmead Police Station. So I think both incidents were at Broadbury and not Southmead. But in any event, I'm dragged there. I'm taken there in handcuffs, shackled, to be interviewed for the incident earlier that day at Bedminster Job Centre. And of course, I just simply give an account of what I've just told you just now. And there's no point in repeating it because I simply give an account. I think it's very unlikely I'll find the tape of the interview, but at the interview I'm given a solicitor, and I'll try and bring up the name for the final cut of this documentary. But my defence is, of course, that I haven't. I should obviously point out that I'm accused of hitting Povey in the face, and he's got a slight mark to his face, which you can see in the footage. He touches when I'm down, when he's coming back from having pursued me down the ramp. Ryan himself said that I gave him a black eye, and I punched him. I didn't punch either of them. Of course, I'm holding the camera in one hand, and the incident's being filmed, and at no stage do you see on the film my lashing out at them or hitting them. And what I did say was that if I did hit them, which I didn't, I'm clearly justified because it's self-defense, because I'm being criminally assaulted. I'm doing nothing wrong. I'm just simply entering a job centre. I'm not, whether I'm banned as a civil matter, that's not a criminal matter, and I'm not committing any offence. And obviously, under the law, and of course, I'm a lot more versed in it in self-defense and these issues than I was in 2009. I've had to be, because I've had to defend myself in every single case that I've been prosecuted under, and of course, in some occasions, litigated against. But at the time, everybody knows the general principles of self-defense. I was under sustained violent attack. I wasn't committing an offence. I was obviously going about I was doing something lawful because I was trying to obtain evidence of the amount of corruption involving my original arrest, and certainly in terms of the allegation that there was no CCTV camera footage or camera available at the corner of the incident where I was first attacked by Walters. So and when I made this comment about me, even if I did hit them, not saying that I did hit them, but even if I did or had done, it would have been justified. Then this very large solicitor, complete corrupt person, interrupted me, and he's on behalf of the police. Effectively, he said, "Well, if you hit them, then you've committed an assault," which is obviously ludicrous because people can kill people without them committing murder. It's to do with context and obviously the issue of self-defense. So he's taking the side of the police that I'm not entitled to use self-defense, even if I'm being under sustained attack from these animals. And of course, I'm under life-threatening assault from them. They're pushing me against railings, which of course could have broken my back or caused all kinds of mad. They don't know if I've got a weak heart, and they could have even caused major injury or involved any other innocent bystander who's trying to get in and out of the job centre whilst this madness is going on. So. The conclusion there is that I am charged for assaulting for common assault against Povey and Ryan. Ryan Povey referring to the mark on his eye, and Ryan claiming that he had received a black eye from myself. And I was showing photographs of Ryan with a big fat bruiser on his eye, and there's no way I could have that I didn't, if there was some inadvertent contact, and I accepted that the mark to Povey's eye might have been caused by him attacking me and him catching the edge of my camera or a fingernail or something. But there's no way I would have been aware if I'd hit somebody enough to give them a substantial black eye. Both of those officers are much smaller than me. I'm not much smaller, but a little bit smaller than me. And obviously, if I'm a largish chap and reasonably strong, and if I punched somebody, then I could have quite easily given them a black eye. But I didn't punch them. I didn't punch Ryan at all. So let's look at some of the statements that were made by the various security guards and other members of staff, and compare it to the footage and compare it to the other statements. And we'll see the extent of perjury and corruption that was involved in trumping up these charges of assaulting the two security staff. The first statement I'll read is from Birchall Dick. And we'll notice that Birchall Dick's statement was made on the 7th of January 2010. So this was actually made some 5 months after the incident. The incident took place in September, beginning of August, excuse me. So there's this is now nearly 5 months after the incident. So the police didn't even bother. This was a man involved in the actual violent incident. He was the only security guard who wasn't claiming to be a victim of assault from me, and yet the police weren't interested in what he had to say until 5 months after the actual incident itself. And his statement is as follows: I am the above named person and currently reside at the address given over leave to police. I'm currently employed by Securitas as the security officer covering for other officers who are on leave or off sick. I have been in this role for around 1 year, and my duties are patrolling and to deal with problems with members of the public who may be being aggressive or misbehaving. Of course, the members of the public they're supposed to deal with any kind of violent incident, but it's only the members of the public. So it could be if a member of staff is being violent, or if there's another security guard, then according to Mr. Birchall, that's not of interest to them. Anyway, on Monday, 3rd of August 2009, it's around 2:30 to 3 p.m. I was on duty working at Job Centre Plus, Kent Street, Bedminster, Bristol. At this time, I was stood at the main entrance exit to the job centre with my colleague Paul and Kevin. I do not know their surnames. Paul and Kevin had already explained that they had some problems with a male called Mr. Gray. I do not recall his first name. Paul and Kevin told me that Gray was banned and we were not allowing him in if he tries to. So no interest in the actual legalities of whether that's actually legal to actually use force to keep me from, even if I was banned. And it's, as I pointed out, it's only a civil ban. It's not a ban from the court. So it's not even a ban from a civil court. It's not a ban of any description. It's just a solicitor who said, "Oh, you give me a chunk of money, I'll say that Mr. Gray is banned." I mean, absolute madness and completely corrupt, obviously. At this, I saw Gray coming to the job centre and locking his bicycle up outside. Gray approaches the doors with a video camera in one of his hands. As Gray approached, I believe it was Kevin, explained to Gray that he was banned and not allowed to come in. With this, Gray said something like, "It's a public building, I have got a right to enter and you have no right to stop me." Gray was holding the camera up and holding the lens near our faces, and he was recording us. Gray then started to try and push his way past me, Kevin and Paul, using his body, trying to force his way through. We kept explaining to Gray that he was banned and not allowed to come in. We kept standing back and raising our hands with open palms to try and stop Gray entering the building, but Gray kept trying to force his way in. Gray then started pushing Paul and Kevin, and was calling Paul and Kevin a bald-headed idiot. Gray was constantly trying to push his way past them, and he started throwing punches with a right fist. I think he had the video camera in his left hand. On a few occasions, Gray tried to force his way in, and we had to push him back using force, and Gray was throwing punches again. So I'm repeatedly, I mean, we can see how close I am to these individuals. If I was repeatedly throwing punches, some of it would have been caught on camera, quite obviously. I accept that the footage that I'm showing isn't all the footage, because it had to be broken down because these are just bits that I've managed to obtain from years ago. But obviously, there would have been some clear earmarked point where I was throwing punches, and this would have been alluded to. Should have been alluded to at some point in the proceedings, but we'll come back to that. This went on for around 50 minutes, and there were several people waiting outside trying to get in but could not. After a while, Gray left and said he would be back. Whilst Gray was trying to get in the manager of the job centre, that's Ruth Lacey, I did not know his name, but it's actually a female, came to the door with a letter which said to Gray, was a letter explaining he was banned and had details of how he could sign for benefits. Gray's reaction to this was, "It's a public building, you have no right to stop me coming in." Gray took the letter from the manager and threw it back inside the building without reading it. After Gray left, I noticed that both Kevin and Paul had a black eye, which they didn't have before Gray arrived. At no point did me, Paul, or Kevin do anything other than push Gray back, but only when he tried to force his way in. I did not see how Paul or Kevin received their injuries, but I was stood behind them most of the incident, but they were close enough to Gray to be injured by him. I did not receive any injuries, but I think Gray's behaviour was terrible. He showed a lack of respect to the security officers and the manager who was trying to help. There was quite a few people in the building and outside, and I feel his behaviour was unacceptable in front of so many people. The incident lasted around 15 minutes. At the closest point, I was arm's length from Gray. Visibility was good due to it being daylight. The only obstruction to my view were Paul and Kevin, as I was stood behind them, but could see past the side of them or between them. As I say, I only know the male surname as Gray, as I've seen Gray at the job centre in Kingswood before Christmas, and would recognise him if I saw him again. I fully support the police investigation and willing to attend court if required. So, there's nothing more to say on that at this point. Then we have a witness called Elizabeth Rockatch. Now, Elizabeth Rockatch is just one of the spectators to the violence, who sort of stood alongside. We can see the back of her head, possibly alongside Ruth Lacey, who I pointed out already, So her visibility would have been even less than Birchall Dick's. I mean, Birchall Dick saying that he was behind the security staff. I mean, he was parallel with them for much of the time. And clearly the main point is his focus was on me. He could clearly see me. And therefore, if I had struck both the security guards on two separate occasions at least, or the Birchall Dick says I'm repeatedly throwing punches. And it's very unlikely that I would have missed at that close proximity any of the punches. But Birchall Dick is unable to identify seeing me actually land a punch on neither of these security guards, which is can't be because his view is obstructed. Because even if he can't see that clearly, he can clearly, if you're right, if you're as close as he clearly is to the incident, you would have seen surely a low landing or the recoil from it, etc. Anyway. So we have a statement here. Again, the statement's only made nearly half a year after the incident. So again, the police don't want they're not interested in what Rockatch has to say or any individual independent witnesses. They're not independent because obviously they're all close colleagues of the security officers, they're not officers, but security guards, who are the complainants. So they're not independent, but they aren't the complainants themselves, which is something. But the police aren't interested in what they have to say. So they're going to get all these statements that are then going to be tailored to fit in to some extent to the allegation, rather than finding out what the testimony is and then seeing whether there's a case to answer. I am the above-named person and I reside at the address given over leave to police. I am currently employed by Job Centre Plus and work as advisory service manager at the Kent Street Bedminster branch, and I have been in this role for 18 months. My main duties include managing and supervising a team of advisors who give advice to help the public get back into work. On Monday, 3rd of August 2009, at around 2 p.m, I was sat in my office. It's interesting to note that both these, I'm not even sure to the extent to which these actual witnesses gave specific evidence to specific officers, because both of them, for instance, have said that they use third, which most people say would say three and an RD, little RD next to it. Both those witness statements have RS, so that it does indicate that it's the same officer who's creating the same statements, and it's not even clear whether they're actually providing specific evidence, specific statements. But anyway, at around 2 p.m, I was sat in my office when one of my colleagues explained that Benjamin Gray was outside the building. Benjamin had been, so I'm now Benjamin. The other, how offensive to be called by your first name by people that are giving testimony, trying to get you banged up and certainly perjuring themselves to get you locked up or convicted for offences. I'm not exactly on first name terms with these people, but anyway. One of my colleagues explained that Benjamin Gray was outside the building. Benjamin had been in the job centre and caused problems by trying to pick up a chair and throw it at someone, and therefore we felt he was a threat, and Benjamin Gray was sent a banning letter from our solicitors stating he was banned from all the offices in Bristol. I did not witness this incident, but I was working that day and saw Benjamin Gray being spoken to by Ruth Lacey, the job centre manager. Which is why I forgot to mention it was Ruth Lacey who was involved in having me removed and with the police on the 24th of July. So she was very much a witness to the ongoing and colluding in the ongoing attacks that I'd suffered on that day. On this day, I heard Benjamin was outside, so I went to the window looking over Kent Street and saw Benjamin sat on a wall. I hovered around looking out of the window and said to a member of staff, if anything happens, come and get me. But it's not, why would she... At about 10 minutes later, another member of staff came back to my office and told me Benjamin was approaching the door, and so I went downstairs to make sure everything was all right. When I got to the bottom of the stairs, I heard raised voices, and as I walked past the welcome podium, which is approximately the welcome podium, I mean, can you believe it, which is approximately 4 meters from the main entrance exit, I saw 3 security officers, Paul Povey, Kevin and Birchill, all stood in the doorway, and Benjamin stood in front of them. The first thing I saw was Benjamin throw a punch with a clenched fist hitting Paul in the face. I do not recall which hand was used. I continued walking towards the doors and stopped behind Kevin and Paul about half a metre behind. I saw that Benjamin had a video camera in his hand and he was shouting at the security officers in an aggressive manner. You can't ban me, this is against the law. He kept repeating himself and saying, I have rights. Benjamin kept pushing Kevin and Paul with open palms and pushing the video camera into Kevin and Paul's chests. Kevin and Paul kept telling Benjamin he couldn't come in, and Benjamin was also trying to force his way past by pushing his shoulders into Kevin and Paul, trying to push his way between them. This pushing by Benjamin continued for a few minutes, and then Ruth Lacey, the job centre manager, came down and tried to hand Benjamin a letter. So yes, Ruth Lacey is the manager. It's got nothing to do with this Miss Rockash, whatever her name is. The letter was explaining where he needed to go to sign on and the arrangements for it. Ruth tried to hand the letter to Benjamin. Twice she explained what the letter was, and Ruth was offering it to Benjamin with an outstretched arm. I remember seeing the letter on the floor and Ruth picking it up twice. During this time, Benjamin was still shouting, although I do not recall what he was saying. Benjamin was then Benjamin then started to try to push past the security officers again, and I saw Benjamin tapping Kevin on the face. I think Benjamin was using a right hand with an open palm hitting Kevin in the cheek. So is it a tap or is it a hit? Literally changing the testimony within 2 sentences. I don't recall which side. I could see this clearly, and it looked like Benjamin was hitting Kevin fairly hard. Kevin did not react to this, and Benjamin continued pushing and trying to push past security. There were people waiting to get in, and all in and out, all through, and I remember 2 young girls around 6 to 8 years of age in the building, and I was concerned for people's safety. We tried to lock the doors, and so when there was a gap, the security officers came inside and we shut the doors, locking Benjamin outside. I feel that Benjamin's actions were aggressive, and it was frightening. He would not listen to anything we were saying, and he was shouting over the top of us. I felt he was goading the security officers by pushing him and tapping Kevin's face, and I feel he was looking to get a reaction from them. The incident lasted around 20 minutes. I was only about half a metre from Benjamin at the closest point. The visibility was good due to it being daylight. The only obstruction to my view of Benjamin were the security officers, but I could see between them, past the side of them and over their shoulders. As I say, I know the male to be Benjamin Gray from the incident the weekend, and I have not seen him since, but I will recognise him if I saw him again. I fully support police investigation, and I'm willing to attend court if required. We have another statement. I am the above-named person, and I currently reside at the address given above, given over leave to police. I'm currently employed by the Job Centre Plus, Kent Street, Bedminster, Bristol, as a customer service manager. A lot of managers. We've got an advisor, well, she's a customer service manager. Rockhatch was a manager. Lacey's a manager. Perhaps a little too many managers. I'm currently employed by Job Centre Plus, Kent Street, Bedminster, Bristol, as a customer service manager. So yet another manager. I've worked at this branch since June 2009. I've worked for Job Centre for 3 years and 8 months. On Monday, 3rd of August 2009, again, third spelled 3 RS, which is a very unusual way of saying third. I was working in my role at the time as a floor manager, and of course indicating that it's the same police officer who does give the impression that they're writing the statement and they're just getting them to sign to it. My duties included working on the podium, welcoming customers and answering their questions. In the afternoon of approximately 3:30, I was working on the welcoming podium situated around 4 to 5 meters from the main entrance to the building. At this time, security guards told me that Ben Gray was outside locking his bicycle. The security guards on the day were Kevin Ryan and Paul Povey, and a third, Birchall Dick. I know Ben Gray from previous dealings, and I first met him at Eagle House Job Centre a year before this incident. Security then told me Ben had left at around 15 minutes later. Ben returned. I was still on the podium, and Ben approached the front entrance. So I've gone from Mr. Gray to Benjamin. Now I'm Ben. But I'm on this friendly terms with these people that are trying to get me banged up. It really is quite weird and quite sinister. I was still on the podium, and Ben approached the front entrance, and the security guards were stood side by side in the doorway. I could see Ben had a video camera, and he was holding it up high above his head. I could hear shouting from Ben, but I do not recall what he was saying, as I was dealing with another customer. Security were trying to let other customers in, and as they did so, Ben would try and push and barge his way through the gap, but security managed to stop him. After a few minutes, Ruth Lucy, the job centre manager, and Karen Rockash, the advisory manager, were stood behind the security guards. I could hear Ben shouting, "Are you the manager? You have these bald-headed goons. Are they your army?" or words to that effect. I continued dealing with other customers, and so was not looking at Ben and the security all the time. At one point, I remember seeing Ben's arm in the air and Kevin's head moving to one side, and Kevin saying, "That's the second time you've hit me. Don't do it again." Due to where I was stood, I didn't see if it was a punch or slap or how Ben hit Kevin. Ben then started to shout, "Go on then, hit me," or something similar. Ben kept lunging forward into Kevin, Paul and Birchall, trying to get in, but he didn't. But he was barging in to the security guards. Another member of the staff told me that 2 children were crying on the sofa. Well, whose fault is the children crying? It is the fault of these thug security guards. If they didn't want me in, they should have closed the door, they should have called the police, and then the legalities surrounding whether or not I'm entitled to enter the building could have been resolved by that way. Who's these 2 girls? I went to check on this and saw 2 girls, both 7 and 8 years of age, both in floods of tears and crying. Both were with their mothers, who were saying they're frightened. Well, this is hearsay anyway, but I reassured them and got them a drink. I reassured them and got them a drink, and one was struggling to breathe. I managed to calm them down, but I could still hear shouting coming from the front door. And of course, none of this, all of this incident surrounding the 3rd of August is only because the police have colluded in the perjury and the perverting justice and the violence and the attempted strangulation from Ryan and Walters a couple of weeks earlier, and then they've scapegoated me for that incident, and then they're illegally enforcing this so-called ban 2 weeks later. As there were people trying to leave but couldn't, we opened the staff entrance exit for the customers to leave. I then returned to the podium where Ben was still shouting. Eventually, the security man managed to shut the door and lock Ben outside. Well, they could have done that at any time. They didn't just suddenly manage to do that. Well, Bertram Dick said it lasted for 15 minutes or approximately. Nothing like 15 minutes. It was 5 minutes at best. But they could have locked the door when they saw me coming towards the door, let alone at any stage during the altercation prior to that, since that, after that. Ben continued to shout through the door, pointing the video camera through the glass doors. Eventually, Ben left completely, and I have not seen him since. I find Ben unpredictable, and I think she means feel, I do not know how he may act. It was quite a scary incident. I was worried for the security guard's safety and mine, wondering what he might do if he got inside. So, I mean, absolutely no concern about any of the violence or the injury that they could have caused me, let alone the people trying to get in and out of the job centre. I'm simply an inanimate object. I have no humanity. The incident lasted a total of 20 minutes, and the closest point was 4 to 5 metres from Ben. Visibility was good due to it being daylight. The obstructions to my view were the security guards, but I could see past their shoulders and gaps between the security guards. I fully support the police investigation and am willing to attend court if required. Then we have Karen Ann Smith, yet another security. She's another service manager. So, I mean, if they're all managers, is there any member of staff that isn't actually a manager? I ask the question. And of course, again, this obsession with status. I'm the above-named person and currently reside at the address given over leave to police. I'm currently employed as a customer service manager at Job Centre Plus, Kent Street, Bedminster Job Centre, Bristol, and I have been at this job centre for a year. I previously worked as a frontline officer at Job Centre Plus, Eagle House, St Stephen Street, Bristol, and I worked there for 3 years. The job centre is a place for people who come and look for jobs, and also for people to come and claim job seekers' allowances. On 3rd of August 2009, at around 1 p.m, I was at work, stood by the welcoming podium, which is situated about 3 to 4 metres away from the entrance to the building. I was talking to Jess Brown, another employee. At this time, I saw Kevin Ryan and Paul Povey, 2 of our security officers, rushing toward the entrance doors to the buildings. I looked over toward the doors and I saw Kevin Ryan and Paul stood in the entrance to the building, and I saw a male stood outside. I know this male as being Benjamin Gray. I know Benjamin from Eagle House, where he was signing on for job seekers' allowance, and I also know him from the week before where he came to the job centre, Kent Street, and Benjamin started arguing with another customer and he picked up a chair and he was arrested by police. So what kind of version of events is that? She doesn't even accuse me of throwing the chair. She was actually present on the 24th of July. So she must have been witness to at least some of what has gone on. And she doesn't even accuse me of the general lie that's now gone around that I've been throwing chairs at people, which for some reason didn't involve the police insofar as my being charged or even bailed given bail conditions in relation to. On this occasion, Benjamin was stood outside holding a video camera. Benjamin was shouting at Kevin and Paul to let him into the job centre, and I heard Kevin and Paul saying he wasn't allowed to film inside the building and so they weren't going to let him in. Benjamin was so apparently this is now to do with me filming. Sorry, let me just. So she's claiming that I wasn't allowed to into the building because I was filming. So nothing to do with the ban, according to Miss Smith's version. Benjamin continued talking to Kevin and Paul, and I saw Benjamin trying to push his way past Kevin and Paul to get inside. This didn't work, and Benjamin tried a few times to push past to no avail. This continued for around 20 minutes, and at one point I saw Benjamin throw a punch at Paul, hitting Paul in the face. I do not recall which side of Paul's face the punch landed on or which hand was used, but it was definitely a clenched fist. Benjamin used. Also, whilst this was going on, Ruth Lacey, the office manager, and Karen Rockash, the advisor manager, were both stood behind Kevin and Paul. At this point, Ruth told Kevin and Paul to shut the doors, and because Benjamin was stood right in the doorway, I saw one of the security officers, I cannot recall which, push Benjamin back and then shut the doors in order to keep him outside. Whilst this was happening, I called the police, and after the doors were closed, Benjamin left. At this point, I felt relieved that the doors would close, as I was concerned for the safety of my colleagues and also the 10 to 15 customers who were inside. At one point, a baby started crying, and the baby and their mother, along with another customer, had to leave via the rear staff entrance. So we now got a baby crying as well. Again, all the faults of the violence carried out by the guards, nothing to do with me at all. My only offence, even by the version of most of these individuals, is trying to get into the job centre. That's it. If I did punch them, which is a complete fabrication, I didn't, but even if I did, it's in self-defence from the violence they are bringing to me. It was not a pleasant experience, and it became a bit of a shock, but I think Benjamin's behaviour was appalling and extremely unpleasant. The guards, meanwhile, are absolutely lovely, charming individuals. We can also hear there's them swearing. I'll try and find the recording of that I took on my dictaphone, but Povey in particular is effing and blinding continually at me. The incident lasted around 20 minutes, and I was stood around 3 to 4 meters away. The visibility was good due to the daylight and artificial light in the building. So here we have the statement for Paul John Povey, who was one of the security guards claiming to be the victim of a punch from myself, or a tap, depending on which version you believe. I am the above-named person, and I currently live at the address over Leaf. For just over 2 years, I've been employed by Securitas as a customer care officer. In this capacity, I work at the job centre on Ken Street in Bedminster, taking care of customers and staff and making sure that it's a safe environment. At about 2:30 p.m. on Monday, 3rd of August 2009, I was at work when I was made aware by Kevin Baker, one of the job centre staff, that Mr Gray was at the bottom of Kent Street. He was of significance. Mr Gray had been sent a banning order, not a banning order, a letter, but never mind, stating that he was banned from the job centre. He should have received this earlier yesterday or this morning. He was banned from the centre whilst I was on holiday due to his conduct at the centre. I went to the front door and to check that it was Gray that Kevin had seen. I looked down Kent Street to see Mr Gray chaining his push bike up against a lamppost about 30 feet away from the job centre. Gray saw me looking down, and he went into his mobile phone and was talking to somebody. He was marching up and down. Well, that would have been the police asking them to intervene so there wasn't any public order issues and crying children and allegations of people getting hit. And of course, as a result, we're talking about 40, 50, 60,000 pounds of public taxpayers' money when the dust settled on these proceedings. Gray saw me looking down, and he went onto his mobile phone and was talking to somebody. He was marching up and down and waving his arms around. However, because I'm a bit deaf, I could not hear what he was saying. As soon as I heard Gray radioed my colleague, Kevin Ryan, to tell him to come to the front entrance. Gray came down, and we both stood there in the doorway. Gray was still on his mobile phone, marching up and down. We stood just inside the door then, so that we weren't provoking Gray and he could not see us. Gray was marching up and down on his mobile phone for a little while, but he then left. However, his bike was still there. A short time after, a police officer turned up asking if somebody had rung for the police, but we said that we had not. That would have been me. He then left Gray. He then left as Gray had gone. However, about 25 minutes later, Gray returned. However, I noticed that he was now smartly dressed in a shirt and tie, whereas before he was wearing a t-shirt. Gray made a beeline towards the job centre entrance, and he was holding a camera. He tried to barge his way past Kevin and I. He said, "It's my right to come to the job centre." We told him that he had been banned, but he replied, "You can't ban me. It's my right to claim benefits." He kept on shouting, but I just drowned it out as I was concentrating on not letting him into the centre. Gray was being very aggressive and was almost poking me in the eye with the camcorder he had it that close to me. There were people trying to squeeze by in or out of the job centre, and whenever a gap opened, he tried to squeeze through. However, I blocked his path, and he really lunged at me, pushing me back. I pushed him away with my open palms, and I pushed him towards the gangway as he was barging at me. However, he kept waving his arms about, and I still had my palms up to stop him from pushing past us into the centre, but he punched me in my left eye. His left hand was clenched into a fist. I said, "You've just assaulted me," to which he replied, "No, you just assaulted me by not letting me into the job centre." At this point, somebody went and told Ruth, the manager, that Gray was outside, and Ruth and Karen, the managers, came down and stood behind us. Well, of course, if it was at this point, then they wouldn't have witnessed the punch that Povia says I've already administered to him. It was very busy. There was a crowd watching, and I got the feeling that Gray was being exhibitionist, like an actor making a scene for the crowd. The more people that were, there's no scene if I'm allowed, if they either let me into the job centre or they close the doors to prevent me getting in. Then if I was, and how could I on my own be creating the scene without these 2 or 3 security guards using violence to keep me from the job centre? I mean, people aren't going to just ignore that kind of violence, are they? It's hard. It would be anybody who's involved in any form of violence, whether the victim or the perpetrator, or it's 6 of one, half a dozen of the other, would by that rationale be actors trying to make an exhibition of themselves. But anyway, the more people that were watching, the more aggressive he got. Also, the more we stopped him from coming in, and the more that he didn't get his own way, the more aggressive he got. At one stage, we were actually in a bit of a tussle as Gray was trying to push past Kevin and I, as we would not let him through. Gray then walked down the gangway, and a woman outside started to shout that we should let him in because it was his right. Gray then got very aggressive with Kevin. He slapped Kevin round his face, and Kevin said, "Don't do that." Kevin remained calm, but this just seemed to wind Gray up even more. "What are you going to do to stop me?" he said, before slapping Kevin again, even harder. One was a slap, but the second might have been a punch. It was much harder, and I could see that Gray. So he says that he said that I slapped him even harder. Then he said it may have been a punch. So it's again just contradicting their own testimony within the space of 2 sentences. There was Gray was getting out of. It was much harder, and I could see that Gray was getting out of hand. There was a lot going on. At this stage, I managed to lean over Kevin and managed to get my keys in the door lock. I was still trying to stop Gray from getting in, but I managed to pull the lock and close the door on Gray. He said that he was going to come back every day because it was his right. He was calling me all sorts, but I just took no notice of what he was saying. I'm very annoyed with what has happened today. Kevin and I both remained professional, but Gray would not see reason. In his mind, he seemed determined to get one of us to hit him back. However, we remained professional and merely stopped him from gaining access to the centre. Well, we can clearly see they pushed me against railings, so I'm well out of anywhere near the doorway, but they're still continuing to push me and potentially commit a serious injury by pushing me against the metal railings behind me. I felt upset by this incident. As a result of Gray hitting me, I have a black eye, a headache, and my back hurts. This is because at one point when Gray tried to push past me, he had me bent backwards. Gray is big. You don't really get headaches from being bent backwards, but anyway, Gray is big and very strong. When he tried to get in, he was using all of his power to try and get in. It was, it was only our willpower that stopped him getting in. He obviously doesn't know what willpower is, but anyway, nobody has the right to assault me, and I fully back any police action regarding this incident, and I am prepared to go to court regarding this. I also give the police access to my medical records in relation to this incident. Gray is a white male aged in his 40s. He is about 6'2" tall and has a slim to stocky build. He was wearing glasses and a camouflaged baseball bat. He also wore a blue shirt and white trainers. He was carrying a camcorder in his right hand and had a bag. This incident lasted about 15 minutes from when Gray arrived to when he left. However, it is hard to say as it felt like a long time. At the closest, Gray was on top of me. At the closest, Gray was right on top of me. Kevin dealt with him for the majority of the time, but at some point, Gray had his camera right in my face. He seemed to only be doing it to get a response. The visibility was good as it was a bright day and there were no obstructions to my view of Gray. I have met Gray before. He has been coming to the job centre about a month after he was banned from the centres. I have had this statement read to me and agree with its contents. This is the second statement by. We've heard Ryan's statement in relation to the 24th of July. This is now made on the day of the incident of the 3rd of August. I am the above-named person and currently live at the address Overleaf. I am currently employed by Securitas as a customer care officer. I have done this for about 5 years now. In this capacity, I work at job centres and provide that the customers follow office rules and procedures and ensure the safety of the staff. On Monday, 3rd of August 2009, at about 2:30 p.m, I was working at the job centre on Kent Street in Bedminster. At this time, I had a call on my radio from my colleague Paul Povey telling me that Ben Gray was outside the job centre and asking if I could come to the front entrance to help him stop Gray from getting inside the centre. This is because Gray is banned from the site due to past incidents where he has been fighting with other customers, running around the office, throwing chairs and causing a disturbance. I went round to the front with Paul. And so this is the incident in which he's already said that he's seen me throwing chairs. So he's the perpetrator of the fabrication that I'm throwing chairs, that everyone is now quoting, 2 weeks later, even those who claim not to have been there or not to have seen the incident. I went around to the front with Paul and we waited and looked to see if Gray was coming into the office. Gray was standing about 15 metres away on Kent Street where his push bike was chained up. He was on his mobile phone, but I did not know who he was speaking to. I heard Gray say, "I've received a letter telling me that I'm banned and I'm not allowed inside, but they can't do that." I couldn't hear all of the conversation due to the noise of people coming and going, but I did also hear him say, "I'll meet you round the corner." I think that he was on the phone to the police as he called them before in the past. Well, just briefly pausing there, because we've had the police apparently turn up 15 minutes. So they would argue that they did respond to my call by turning up. Well, they've turned up and they've left, but of course they've got my mobile phone number. So why didn't they call me to say, well, you're not here, you've called the police, what's the incident about, shall we meet you there, etc. So they allegedly turned up and then vanished into the night again, as again is one of the modus operandi. I think that that he was on the phone to the police and he called them before in the past. Gray then walked off round the corner into West Street and out of my sight. About 15 minutes later, a police officer turned up and said that he had a call that Gray was there. Sorry, Gray was here. We informed the officer that Gray was banned and that he had been informed that he had been banned. As he was not actually there at the time, the officer said that there was nothing he could do but to call if he came back and tried to get in. So in this version, he's now treating me, although it's accepted, certainly by I think Povey, that the police were the officer that turned up, according to Povey, is he didn't know who had called the police, whether it was me complaining about being banned and obviously the threat of violence that was going to ensue if I tried to get into the job centre, or that he was calling, or that it was the job centre who called. So the 99 operator who took the call was clearly, or the police themselves was just lying their heads off, because they would have known whether it was which side of the fence that phone call had been about. But this officer, according to Ryan, has clearly taken their side, and he's treating me as the perpetrator. And they should call the police if I turn up, even though I was the one who actually called the police complaining about violence to them. This is how evil and corrupt the police are in the Avon Somerset police. Anyway, so we stayed at the front entrance and kept an eye out for Gray, who came back at about 10 to 15 minutes after the police had gone. I noticed that Gray had changed his clothes. He was previously wearing a t-shirt. However, he was now wearing a blue shirt and tie. He spent a couple of minutes talking to another customer outside, and then at about 3 p.m. he came marching up to the front entrance with his camcorder in his hand. He was holding the camcorder in his right hand, and he showed it right up, and he shoved it right up to my face and said, "I want to come in." I told him that he was banned and that he was not allowed into the office and that he was not allowed to film us. At this stage, Paul and I were standing in the entrance in order to stop Gray from getting inside. Gray then said, "You're stopping my right of way. You can't stop me from coming in. I'm allowed in. I've been told by the High Court judge I'm allowed in. You can't stop me." He was shouting aggressively and was coming right up into my face and Paul's face and thrusting the camera right into our faces. He then lunged forward and took 2 swipes at Paul. He used his left hand and that was a clenched fist. The first strike missed, but the second one hit Paul in his face. I think he might also have hit out at Paul with the camera. We both then pushed Gray back. I pushed Gray backwards as he was coming at us, and had my hands open, pushing back at Gray with my palms. Gray then moved back down the walkway and started shouting, "You've assaulted me, you're thugs." We told Gray that actually he had just assaulted us by pushing me and hitting Paul in the face. We then stood back in the doorway, but Gray came back at us again, shoving the camera in our faces and saying, "You're hired thugs, you can't stop me from coming in, it's my right, I've been to court and they've told me I can come in." He then started shouting over our heads at the managers who were standing behind us, "You can't stop me coming in and signing. I have a right to sign." I had no interest in signing. I wasn't there to sign on, or it may have been another issue. But the main purpose was to film the evidence of the camera of the part of the building where they said there was no camera or that it wasn't operational or whatever the excuse was. So I'm there to gather evidence primarily to prove the assault and the perjury and the perverting justice from a few days before. The manager, Ruth, then gave Gray a letter that explained to Gray all of the instructions that he had to sign on now that he had been banned. Gray took the letter from Ruth, but then just threw it back at her in her face. Customers were trying to come into the into the centre and also to leave. However, every time we let other customers in or out, Gray tried to barge past us and get inside. I put my left hand up, palm facing Gray, in order to try to keep a distance between us. However, he kept just hitting my arm and my hand and shoving his camera even closer towards my face. He continually shouted that he'd been allowed to sign. I explained to him that the letter explained to him everything that he needed to do, but he shouted back, "The judge will have to give me that in court." Once again, he tried to barge in, but we managed to keep him out. He then hit me in the face. I think it was with his left hand, but I do not know if he hit me with his fist or his open hand. I said to him, "You've assaulted me now," to which he replied, "You've assaulted me. You've elbowed me in the ribs." At this point, Gray started goading me. He said, "What are you going to do?" And kept lurching towards me as he was going to try and get inside or hit me. He then slapped me in the face with his left hand and goaded me by saying, "What are you going to do?" I think that he was trying to goad me into hitting him back, because the more I didn't react to him, the more he was goading me and the angrier he was getting. At that point, Paul pulled the door shut and locked it. I think that if Gray hadn't done this, Gray would have assaulted me even further. He was He was getting himself more and more worked up and aggressive, and seemed to be getting worse because I was rising to his goading me. Gray shouted out, because I wasn't rising to his goading me. Gray shouted out, "You can't stop me from coming in. I'll be back tomorrow morning and the morning after, and I'm going to come in." He then hung around for a few minutes, talking to customers outside before walking off towards West Street. Gray's behaviour had disrupted the whole office, which was not in a state of upheaval. He probably means in a state of upheaval. Customers had not been, nobody even bothered to read through these statements before they're signed, because they don't even make grammatical sense, anyway. Customers had not been able to get in or out, and there were 2 little girls who were standing inside crying because of Gray's aggressive behaviour, and nothing to do with the security guards aren't aggressive at all. Mr. Povies is, we can see how lovely he is when he's shoving me against railings and so forth, and he's swearing like a trooper, so that would have probably upset anyone, especially little girls. After being assaulted by Gray, the police arrived and took me down to the walk-in medical centre. As a result of it, As a result of being hit by Gray, I now have a large red bruise swelling up on my right cheek, which now hurts. I also have a headache and feel like I have pulled my stomach muscles from straining to keep Gray out of the building. The doctor said that I had possibly torn my stomach muscles. I will now not be able to go to work tomorrow. I am upset by this, as Gray has clearly gone to the job centre knowing full well that he was banned, with the sole intention of causing trouble and making a scene. Nobody has any right to assault me in any way, and I fully back any police action in relation to this incident, and I'm willing to go to court regarding the incident. I give the police my permission to access my medical records in relation to this incident. This incident lasted approximately 40 minutes from when Gray first arrived to when he eventually left. However, it was only about 5 minutes. It was only about 5 minutes that he was trying to push past us at the door. It seems a bit longer. At the closest, Gray was right up in my face, physically touching me. The visibility was good as it was clear day and there was no obstruction to my view of Gray. I have known Gray for about a month now. I don't think he's known me. I think we might have met, I don't know, but that's not knowing somebody. I've known Gray for about a month now since he has been coming to the office. However, I was made aware of him because he has been banned from 2 other job centres for causing disturbances. Ben Gray is a white male in his mid to late 40s. He is about 6 foot 2 inches tall and has a large build. He has dark hair, almost black, but starting to go grey in some areas. He wears glasses, and on this occasion looked clean-shaven. He was wearing a camouflage baseball cap and was wearing a pale blue shirt. Skip to the CCTV. At about 5:29, I copied the CCTV from the front entrance to the job centre and handed it to PC DaCosta. So we have now Ruth Hazel Lisi. She is the manager, and there will be managers, but she's, as far as I can make out, the head manager, the manager of the managers, as they would say. I am the above-named person. I currently reside at the address given over leave to police. I'm currently employed by the Job Centre as a manager at the Bedminster office on Kent Street, Bristol. I've been working for the Job Centre for around 20 years and have been manager since the 1st of June 2009. The Job Centre is a place where people can come in and use our computer system to search for jobs, and people can be assisted by our staff to find jobs. I personally am responsible for the building and health and safety of the staff and members of the public. On Friday, the 24th of July 2009, I became aware of the abusive member of the public in the office downstairs. When I went downstairs, I saw security talking to a very irate member of the public. I knew the male member of public to be Benjamin Gray, age 43 years. I had met Benjamin before earlier in July because he made a complaint. Benjamin was quite irate, shouting, screaming, and he was very agitated. I do not recall what he said, but I sat with him and calmed him down until the police arrived and arrested Benjamin. So it's as simple as that. So let's just retrace, because it's all a bit much to take in one go. So she was there on the 24th. So she's not at all interested in giving any evidence or inquiring about why I was allegedly shouting and screaming and being agitated. She didn't witness the scene. She didn't check the CCTV footage. She doesn't even say why I was arrested, even though I was apparently calm by the time the police turned up. After this incident, I spoke to members of the staff and security and filled out a form IF1, Incident Form 1, which goes to our district health and safety coordinators, and sent the form to our department solicitors and requested a banning order be sent to Benjamin Gray, because of this incident. Well, just a slight pause there, because look at all this nonsense. And they've got health and safety coordinators who deal with incidents such as the one that's occurred. So all this money, all this public taxpayers' money, the only people that should be the slightest bit interested or concerned about any violence, any altercation in any public building like a job centre is the police. If the police have evidence there's been a crime, they can put bail conditions on, they can make restraining orders, they will refer it to the court for restraining orders. That they are independent. Why does the taxpayer have to fund for all these extra bodies who are going to decide, obviously in favour of the job centre staff, that a job centre user is in the wrong and needs to be subject to bans or which can't even be enforced legally anyway? That's why they have civil courts if they want to bring an injunction, which they eventually did do. I've now been banned for job centres for the last 10 years, but 7 or 8 years, by courtesy of an injunction that was imposed on me, costing around £25,000 of taxpayers' money. So all this jobs for the boys that is totally redundant, considering the police and the criminal courts. And of course, if they had evidence, even the injunction was £25,000 of wasted money, because they could have just got. Because if I was committing all these offences and all this violence, throwing chairs at people and stuff, then that's the matter for the police and the criminal courts. So anyway, then on Monday the 27th of July 2009, Benjamin Gray returned to our office sometime in the afternoon with camcorder, and I was made aware he had come in, so I watched him on the computer. He then walked away, and I approached and asked him what he was doing. He said he was taking photos of the CCTV cameras because he believed the incident on the 24th of July 2009 wasn't captured on camera. I explained that he couldn't, so she's the only witness to actually give an account of why I turned up, to do with the capturing evidence of the other CCTV camera involved. So she's actually been honest in contrast to all the other witnesses, none of whom refer to anything to do with my wanting to get evidence of criminal misconduct, including in particular by Mr. Ryan, who had colluded in my attack after being savagely strangled by this lunatic Walters. And of course, they talk about girls crying when nobody's the slightest bit concerned that there's this maniac Walters who thinks it's in front of CCTV cameras, in front of security officers, randomly strangling somebody because he's involved in some minor petty dispute about whether he can sit on a chair. So anyway, I explained he couldn't take photos, and Benjamin left. On Monday, so it's a bit confusing because she's saying I turned up on the 27th, right? So at least there's some general understanding of why I'm there with the camera, because which Lisi would have known about, because she says, and she's probably right, I turned up on the 27th, and I didn't try to get in, but I made it clear that I was after evidence surrounding the CCTV camera. On Monday, the 3rd of August 2009, I came into work, and upon reading my emails, I found that the department solicitor, Field Fisher Waterhouse, had sent me an email stating that a letter and banning order had been sent by them to Benjamin Gray's home on the 31st of August 2009. Included in the email was a copy of the letter I sent. I produced this to PC Botley, and I think he was the officer with DaCosta when I was arrested on the 3rd. Anyway, later that day at around 1:30 p.m, he had been informed that Benjamin had turned up at the office again and been sent away. During that day, I had written a letter addressed to Benjamin Gray, which explained how and where he could claim his benefits now that he has been banned from the Bedminster office. It was in my post tray, ready to be posted. That same day, 3rd of August 2009, at around 2:55 p.m, I was told by a member of security that I was needed urgently downstairs. I suspected that Benjamin may have come back to the office, so I went downstairs, taking the letter I had prepared for him, explaining the benefits with me. As I went downstairs, I heard Benjamin's voice shouting, saying, you've got no right to keep me out here, and it's a public building. Only a judge can stop me from entering a public office, or words to that effect. I saw two of our security officers, Paul Povey and Kevin Ryan, stood in the entrance doorway. I saw Benjamin stood outside with his camcorder in his hand, shouting at security. I went in and stood behind the security officers and tried talking to Benjamin, but he kept shouting over me. I was trying to explain that I had a letter for him, and that would explain how he could claim his benefits, but he didn't seem to listen and kept shouting. I handed the letter to Benjamin, and he initially took the letter only for him to throw it back at me instantly. I picked the letter up off the floor and tried handing it to him, but again he refused to take it and just shouted at me, saying, "You're the job centre manager and you've got no fucking right to deny me entry to a public building." During this time, I wouldn't have sworn, absolute fabrication that I had sworn. During this time, there was a number of people trying to get in and out of the office. In order for people to get in and out The security officers had to move to create a gap. Each time they did this, Benjamin would lunge at security officers, causing them both to stumble backwards. Benjamin must have done this about 6 times. Because I was stood behind the security officers, I could not see exactly what was happening or where Benjamin was hitting the security officers. So we've got almost 50-50, haven't we? Half of the staff behind the security guards, including Virtual Dick, one of the guards himself, says they couldn't see anything because they were behind the guards and couldn't see where if I was punching at all, or if I was punching out, if my punches were landing or where they were landing. And yet another half said that they saw me clearly punching, even though they were often behind several people, let alone where Virtual Dick was, which was at the front line, as it were. Each time they did, Benjamin would lunge. However, I could see. So unfortunately, I've lost the last part of that statement. I'm sure you'll agree it's not pivotal to the general corruption that I'm exposing here, but we'll have to leave that for the moment. Obviously, in any event, her testimony under oath is what's most important, and we'll see what Judge Longman has to say about all that when we come to the judgment. This is a statement from Earl DaCosta. This is surrounding his involvement in my arrest and the investigation into why I was arrested on the 3rd of August 2009. I am Police Constable 1912 DaCosta of the Avon Somerset Constabulary, and am currently stationed at Broadbury Road Police Station in Knowles, South Bristol. These are my original notes, and was started at 23:45 hours on Monday, 3rd of August 2009 at Broadbury Road Police Station, report writing room. On 3rd of August 2009 at 15:29 hours, I was on duty in full uniform. At this time, I was at the Job Centre on Kent Street viewing CCTV footage from an incident that happened earlier at approximately 1500 hours, whereby Ben Gray, who was banned from the site, attempted to gain access to the property and in doing so assaulted the 2 staff. So there's no suggestion that these are allegations. I've carried out the assaults, according to this officer, before he's even turned up to arrest me. The CCTV footage showed the two victims standing in the doorway as Gray shoved the camcorder in their faces and repeatedly attempted to push past them. At one point, I could see Gray lash out and strike one of the staff members. So this officer is claimed to have actually seen me hit one of these staff. He claims not to. He doesn't give any description about what they're doing to me, but put that to one side, let alone self-defense, let alone them assaulting me. But he claims to have seen on the footage an actual strike carried out by the officers. And we'll come back to that because we'll see that there's no mention of that when Judge Longman gives his statement, having viewed the footage many, many times. For most of the footage, Gray's head was out of shot. However, there was one part that you could see it, and I recognised him as Ben Gray, who I dealt with in custody the week before, 24/07/09, for a similar offence. Well, yes, I mean, similar allegations which were discontinued, so he's colluded effectively. He's basically saying he colluded in the my being kidnapped and tortured, etc., on the 24th of July. In the footage, Gray was wearing a pale blue shirt and a blue tie. At 1900 hours, after having taken a victim statement from Kevin Ryan, I took a series of photographs of the injuries that Ryan and Paul Povey had received. Ryan had a red lump swelling out of the right side of his face, and Povey had a black eye to his left eye, which was bruised. I later attempted to print out the photographs. However, the computer would print off the photographs. I think he means, obviously, the computer would not print out the photographs. Which we'll see is highly convenient, because we shall see that according to the doctor or the medical examiner, the nurse who examined Ryan, she didn't see anything on his face at the time that DaCosta claims to, or within an hour or two of DaCosta claiming to have photographed, which conveniently didn't print out. So we've got the missing CCTV from the original incident on the 24th, we've got the missing CCTV, and we've got the missing photographs of the printout, which would anyway be digital, retained digitally anyway, and those two disappeared as well. Later on, I think in terrible English, but anyway, later on at approximately 91:45 hours, I was on duty in full uniform in company of PC Alderton, At this time, we attended, it wasn't Botley, it was Alderton, so Botley was there at the interview then. So at this time, we attended 6 Boswell Street in Eastville to carry out, that's my home address, to carry out arrest of Ben Gray regarding the assault that had occurred earlier in the job centre, at the job centre on Kent Street in Bedminster. I knocked several times on the front door, after which a white male, who I noted to be Ben Gray, popped his head out of an upstairs window. He pointed a camcorder at me and started shouting. I asked him to come to the front door in order that I could arrest him in suspicion of assault. I told him that it was about the incident that had happened earlier at the job centre. Gray went inside, and after several minutes he came to the front door. At approximately 91:54 hours, I informed Gray that I was arresting him on suspicion of assault. Gray was shouting over me as I cautioned him and placed him in handcuffs, checking them for tightness. At this point, I did not give Gray the full grounds of arrest, as he would continue to shout over me. PC Alderton double-locked the handcuffs. Gray continued to shout out that we were going to torture him and truss him up. I carried out a search of Gray to make sure that he did not have anything on him that he could use to hurt anybody with. In his shirt pocket, I found an audio tape recorder. I turned this off, and the tape was seized by PC Alderton. I then explained why would it be seized? Because it's not evidence to do with the offence for which I'm being arrested, or the alleged offence I'm being arrested for. So I don't think he had any grounds to actually seize that. But anyway, I then explained to Gray under Section 32 of the Police and Criminal Evidence I was going to carry out a search of his address, and that I was looking for a handheld camcorder that he was alleged to have used to film the assault at the job centre. Again, the assault is absolutely referred to as fact before I've even been interviewed. I then put Gray into the back seat of our marked police vehicle and left him with another officer whilst I went with PC Alderton to search the address. I did not know who this officer was, as he was from another district. At approximately 2200 hours, I found a silver handheld camcorder on the stairs of the property. I seized this and I produce it here as Exhibit 1912 Ed C1. I then went back to our car to watch Gray so that the other officers could resume with their duties. PC Alderton continued with the search, looking for tapes of the camcorder. He came back and informed me that he had found cannabis inside the address at 2202 hours. I further arrested Gray on suspicion of possession of cannabis. I said, because my colleague has found cannabis inside your address, I'm further arresting you on suspicion of possession of cannabis. I then cautioned Gray. Once PC Alderton had concluded with the search, we transported Gray to Broadbury Road Police Station, where we arrived at approximately 22:26 hours. Throughout the journey back to Broadbury Road, Gray was abusive and threatening. He threatened me with violence if he saw me on the street, and he also made some homophobic comments. He also stated that he was going to keep on going back to the job centre. Whilst waiting in the holding cell, Gray stopped ranting for a short period of time. During this time, I explained to him the grounds for the arrest, that he had been alleged to have slapped and punched 2 Securitas employees at the job centre on Kent Street. I also informed him that he'd been arrested in order that we could carry out a prompt and effective investigation by questioning him about the alleged offence. At 22:35 hours, and while still under caution, Gray said he headbutted my camera because he shouldn't have been there. At 23:01 hours, Gray's detention was authorised under custody reference something or other. I had no further dealings with Gray. These are my original notes, and concluded at 12:24 hours on Tuesday, the 4th of August, 2009, at Broadbury Road Police Station writing room. So we have a further statement here that's dated from Da Costa, dated the 9th of June 2010. Now, this surrounds the issue surrounding the missing photos taken of the so-called black eyes from Povey and Ryan, and this is definitely worth reading out. I am Police Constable 1912 Da Costa of the Avon Somerset Constabulary, and I am currently stationed at Broadbury Road Police Station in Knoll, South Bristol. Further to my original statement that I made at 23:45 hours on Monday, the 3rd of August 2009, I would like to make the following points. In my original statement, I mentioned that at 1900 hours on Monday, the 3rd of August 2009, I took photographs of injuries that had been received by the victims Kevin Ryan and Paul Povey, but that I was unable to print off the photographs from a computer. I took these photographs on a digital camera, and they were not printed off or transferred onto a computer, as I could not find the correct lead to link the camera to a computer. I have since looked through the camera in order to see if the photographs that I took are still on the camera available in a digital format. However, they have not been retained. This means that they have been deleted from the camera, probably in order to free up some space on the memory card in order for more photographs to be taken. Although the photographs that I took are now no longer in existence, I did make a note of the injuries on the day that I photographed them. The injuries that I photographed were a red lump and swelling out of the right side of Ryan's face and a black eye to Povey's left eye, which was bruised. Further to this, I would like to add that the photographs that I took were not intended to have any evidential value, but were intended as a visual reference to aid the interviewing officers if they wished to refer to them. I instructed the victims to attend Bishopsworth Police Station in order for trained CSI officers to take evidential photographs for use of any subsequent trial. This was often done a day or so after the incident causing the injury occurred, in order to allow the full extent of the visible bruising to be documented, as it takes time for bruising to come out. Well, that may be the case in some cases, but according to Costa, he saw the bruises, which is why he photographed them on the day. Photographs that were then going to be presented to me, he said, but A, didn't exist, and B, weren't going to be evidence. I don't see how you can provide material to show the interviewer which isn't evidence. That's madness and completely obviously false, as is indeed the existence of photographs ever existing, not having disappeared at some convenient date later on. So I'm not going to bother with the interview from the brief statement from Botley in regards to the interview, because we've got enough material surrounding all of that and only the recording would be worth listening to if I can find it. But in any event, we have a statement here from so we're going back again to the incident on the 24th of July, to the original arrest, because I haven't read out PC Marr's statement. So PC Katie Marr made the following statement on the 22nd of September 2009. So this is to do with the interview that she carried out, and of course my being trussed up on orders of Booker because I'd thrown some water at him. I am Police Constable 4285 Meyer of Avon Somerset Constabulary, currently stationed at Broadbury Road Police Station. At approximately 1800 hours on Friday the 25th of July 2009, I was on duty in full uniform. I was given handover prisoner Benjamin Gray, 11/7/1966, in relation to an affray at the Job Centre, Kent Street, Bedminster. At 1850 hours, I attended Broadbury Road custody and saw D.O. Greatoritz clearing up water from outside his cell. I was asked to commence a constant watch on Gray due to his behaviour. I spoke to P.S. Booker, who stated that Gray had covered the call camera with dirty tissue when he had attended the cell to remove it. He had then been hit with wet tissue and a cup of liquid which had gone into his mouth, or in his mouth. He saw that his shirt was wet and he was wiping his mouth with antiseptic wipes. I went to Gray's cell and saw that he was handcuffed in the rear stap position with limb restraints were placed underneath his knees and on his feet. I sat with Gray for approximately 10 minutes and he kept shouting continually and making threats towards P.S. Booker. He kept on repeating that if anyone came near him and removed his handcuffs, he would spit on them. I stayed silent and did not speak to Gray. After approximately 10 to 15 minutes, he had started to calm down, and I asked P.S. Booker if he could have his handcuffs off. When P.S. When P.S. Booker attended the cell, he tried to speak to Gray, but Gray shouted at him and said, "If you come near me and take those cuffs off, I will spit in your face and kick and punch you." P.S. Booker immediately left, and Gray continued to shout at the top of his voice, making personal threats towards him, stating that he would be on him until the day he dies. It took another 15 to 20 minutes for Gray to calm down sufficiently for him to be released from his handcuffs, and he still kept insisting that no officers could touch him. At 01:25 hours, Gray was arrested for assaulting P.S. Booker and D.C. Tizard. He was reminded he was under caution, to which he made no reply. At 01:26 hours, I carried out a tape-recorded interview in company with solicitor Lee Petters. I'm assuming that's Peters, but it could be Petters. The interview was concluded at 03:32 hours. 3 tapes were used. When Gray So when questioned, Gray admitted to assaulting Booker. I didn't admit to assault. Assault is obviously the offence. That is the offence. I threw water at him, but it was not an assault. It was self-defence, apart from anything, because I've been kidnapped in the first place by throwing wet tissue and water over towards the door as he left the cell. He stated that he was not aware that DC Tizard had also been hit with the water. He stated that he should not have done it and had seen red. I may have said something along those lines, but I would have said I should not have done it in terms of the repercussions on me being trussed up and made to urinate myself. And Ma makes no mention of the fact that I had to urinate myself in front of her because I wasn't permitted to go to the toilet. Why do I need to be trussed up? Because they've got me locked in a cell, so I'm clearly no threat to anybody. And that was just pure corporal degradation punishment. During the interview, Gray kept on repeating that he had swellings and bruising to his hands where his handcuffs had been, and also the injury, because she's not mentioning anything to do with the evidence I've given about the assault from Walters. So I already had an injury from Walters, and then I had further injuries from the handcuffs when I was arrested, albeit I was the victim of the assault from Walters. I could only see some small red marks around this. Well, we can see the drawings. They're pretty bad, considering the medical records, but the medical records show that they're more than just small red marks around his right wrist, and there was no swelling or bruising. Utter fabrication. These marks were consistent with being handcuffed, which I pointed out to him on tape. He also stated he had an injury where he had been grabbed around the neck, but I could not see any marks there. The interview concluded 03:32 hours. I produced the tape interview as my exhibit 4285 KHM1. Gray was then bailed for further inquiries. On 22nd of September 2009, approximately 10 hours, Gray was charged with 2 counts of assaulting a police officer. He was cautioned and made no reply. He refused to sign the record, stating that he had advice once never to sign anything. He was bailed to attend Bristol Magistrates Court on the 6th of October 2009. And of course, the CPS didn't investigate that at all. Withdrew the prosecution, and of course didn't investigate any of my didn't prosecute for my counter allegations, because they were obviously colluding in them, both the assault from Walters and Ryan, and then the assault from Booker and Ma, the inhuman and degrading treatment, including forcing me to urinate myself. But of course, the whole point of the interview was to give my account of the assaults that I had received from these officers, from Walters and Ryan, because that was the original reason that I was arrested. That was the point of my arrest, was to be interviewed about that incident, even though the police could have checked what had happened in 3 minutes by looking at the video, which they didn't do. And they've already seized the video by now, because that's referred to by Ryan himself, who says he handed over the video to whichever officer it was. And yet there's no mention, because Ma has colluded in the vicious, violent assault carried out, which of course terrorized everybody in the building, in the room, as well as myself. The strangulation from Walters, and the video proving the assault, the perjury from Ryan, in particular, that I'd thrown a chair at Walters, or that I had instigated the incident, or that I grabbed Walters around his clothing, and Walters only had me by the clothing around the neck. And she's ignored the witness statement that was further taken, and that Ma had by now, by the time she makes her statement a couple of months later. So she's up to her neck in blood, in perjury and perverting justice. And of course, she's under the auspices, or under the control, of Booker, because he was the sergeant who was controlling the interview. Of course, the more evidence I have that I was the victim of an attack and assault, and that I was being assaulted and kidnapped by the police, to leave me in custody, the more, of course, that proves that I was being kidnapped, and I was entitled to use self-defense against Booker or anybody else who was involved in my kidnap, in relation to that incident. So we come to the statement of PC Bethany Fevin. She was the officer that arrested me on the 24th of July 2009 after the incident with Walters and Ryan. So she says in her sworn statement, I am Police Constable 3773 for Avon Somerset Police, currently based at Broadbury Road Police Station. At approximately 14:20 hours on Friday, the 24th of July 2009, I was on duty, crewed with PC Gaunt and PC Hawkins on mobile patrol in police uniform. At this time, we attended Job Centre plus Kent Street, Bedminster, Bristol on reports via control that there were two males fighting at the premises and refusing to leave. On arrival, I was informed that the two males had now been separated. I spoke to a security guard who worked at the location, and he stated that the males had been fighting, and the male wearing a tie had picked up a chair and thrown it. It was now... I now know the male in the tie to be Benjamin Gray, date of birth 11/7/66. I was further informed that Gray was the main aggressor and had come to the premises shouting about the war. Even we've read Ryan's statement. He makes no. He says I mentioned the war. He claims to state that I've mentioned the war when asking me to stand from the chair. He doesn't say anything about shouting about the war. But in any event, I viewed the CCTV and it showed Gray walking over to an area. So she claims to watch the CCTV, which I hadn't checked before. I viewed the CCTV and it showed Gray walking over to an area that was not covered by CCTV. Well, that was obviously the key reason for my attending on the 3rd, because she says that it is not covered by CCTV. That's utter lies. There was a camera there, but it later was claimed by Ryan and others that the footage didn't come out or that the camera was broken, a very common excuse when I've been attacked with violent offence, often when I'm being strangled, incidentally. But there was no suggestion by Ryan. He might have said that at the time, but well, she would have checked presumably. But there was clearly a camera pointed directly at the area where the incident occurred. It showed the security guards following Gray. They were explaining to me that the male had come into the building and was shouting and being aggressive and shouting at various people for what seemed like no reason. They then explained that there had been a scuffle with two males, Gray and a second male, who gave the details of Philip Walters' date of birth, 22 February 1961, and that Gray had been goading Walters. Well, we've already established from Ryan himself that he doesn't know what caused it. He wasn't witness to any of the initial incident. He just turned around and saw us grabbing each other by the clothes. He doesn't even suggest that he heard us exchange words, even though we're face to face with each other. Including Ryan. They then explained that there had been a scuffle with two males, Gray and a second male, who gave the details of Philip Walters' date of birth. While off camera, I could see a female come from the area that Gray had walked, and she was picking up a bag and looked like she was concerned by something happening as she walked back and was looking to the area not covered by CCTV. She was standing like she had been shocked by something. So I should just pause there because I've got it wrong. I don't recall. I haven't obviously checked this before I made the video. They had claimed that they claimed to have checked the CCTV, which of course makes the situation even worse considering what the footage shows. But so they checked the CCTV. This is apparently all before I was arrested. Of course, it could have happened. They could have looked at it at any time. But in any event, she was standing like she had been shot by something. I could then see on the CCTV Gray, the two security guards and Walters walk back into view and witness Gray pick up a chair and throw it at Walters and the security guards. At this point, Walters was following him but had his hands at his side. The security guard stated that they had to pull the males apart and that they were both fighting. As there were no further witnesses coming forward, we were happy to give words of advice to both parties. Well, no, because we got a full witness statement from Evan, so that clearly wasn't true. Anyway, I went to speak to Gray, who stated that he was not going to leave. So she's saying that I had to. She's totally accepted, or accepted to some extent, that Walters was as much to blame as me. She doesn't. She says she couldn't see what the footage was, but she'd been told that we had just been fighting. Without any details of what usually if two people are fighting anywhere, especially in a crowded, job centre full of other people, including children and so forth, you want to know what the fighting caused, but she makes no inquiry. So Ryan was later to claim in his statement that he wasn't aware of what caused the altercation or caused the original fight. He lies about what the fight consisted of. But she makes no inquiry or no interest into anything apart from me shouting about the war, which had nothing to do with anything, because that was apparently when I came in. It was no mention about the chair or anything to do with that. Anyway, he was verbally loud and stated that although he had no further reason to be there, he was not going to leave until closing time. I mean, nothing of the sort. I just said I wasn't going to leave if I was the victim and being ordered out. And, the point that I was trying to make just a minute ago was that, of course, why isn't Walters being asked to leave? Well, we're both being given words of advice, which was a long way from the allegations of a fray that led me to be arrested a few moments later. Why isn't Walters? Because a fray is usually between two parties. It's usually two people that are fighting that cause the affray. But Walters is allowed to stay. He's not being asked to leave. I felt that there had been problems. I asked Gray to leave on a few occasions, but he refused. I felt that there may be further problems if I left him at the premises. And although I was trying to be calm with him, he was just shouting, "Arrest me, then arrest me." It was clear that he was not concerned about his actions and that words of advice would not be appropriate. I then arrested Gray on suspicion of a fray and cautioned him. I also informed him it was for a prompt and effective investigation. No reply was made. I then placed handcuffs in the rear position for the safety of persons present. Myself, I think she just means rear stand. I don't know why she didn't just say that, but that's behind my back. Myself and my colleagues and Gray and because Gray was placed into the rear of my police vehicle, Gray continued to be verbally aggressive and stating that his blood was boiling. I have no further dealings with Gray. Then we have Walters himself. This statement was made on the 11th of September 2009. So the investigation by Ma, and I use the word very loosely, carries on after my interview, after my release. She's obviously given no indication of what my counter allegations are, so it's largely why she's carrying on with any investigation is obviously very confusing, if not probably just to go through the formality. Anyway, the statement apparently by Mr. Walters is as follows. I am the above named person and I live at the address Overleaf. I am making the statement in relation to an incident that occurred at the Job Centre Plus, Kent Street, Bedminster on the 24th of July 2009. Between 1400 hours and 1430 hours, I went to the Job Centre to sign in. I go there every week and it's always and Friday. Obviously completely gibberish, but anyway, on Friday, the 24th of July 2009, I went to the job centre for my appointment. I walked through the double doors and gave my card to the desk. The security staff stand over on the left. You then go past the desk and to the left where there are chairs to sit in whilst you wait for your appointment. The staff have some cubicles with desks where they speak to you. They all have individual chairs. When you are waiting, you sit on a bench. I was sitting down waiting when I heard a male come into the centre. He was making a lot of noise. He seemed to be moaning, saying that we give £7 million a day to the war and he couldn't get any money. Well, I mean, even if that's what I was doing, if I was moaning, anyway, so it doesn't suggest I was shouting Fevin is the only one that says I was shouting. None of the witnesses to the actual incident, long before Fevin even turned up, says that I was shouting about the war. But anyway, he sat down at the back of the centre in one of the staff chairs. I saw the security guards go over and speak to him. When I wasn't sitting in a staff chair, I was sitting in the chair opposite, the chair that you sit in while you're speaking to the staff. But the staff wasn't there, the table was empty. I saw the security guards go over and talk to him. He was told he couldn't sit there as it belongs to the staff. He started shouting, saying, "Why can't I sit there?" at the top of his voice. He carried on moaning about the war and he then got up. There was plenty of room on the bench seats we were sat on. Another male, to him, he could sit there. Again, illegible or gibberish. The male started shouting at him, saying, "I don't fucking want to sit there." So I'm accused of shouting. Even Ryan doesn't accuse me of swearing, at that stage. I don't think he accused me of swearing at all, actually. But anyway, he says, I don't fucking want to sit there. and gave him a load of abuse. I stood near to him and started to move up. I told him, "You sit there, you sit here," and pointed to where he was, where there was a space. He replied with a load of abuse, shouting at me, "I don't want to fucking sit there." A few other people said there was plenty of room. He was really argumentative and kept saying, "Why should I have to sit there? This is my country." He then grabbed a chair next to him and picked it up. Several people moved as they were concerned he would throw it. I was already standing up, so I put both my hands up to his chest and I told him to calm down. So all of he's clearly deliberately trying to conflate the chair that I did pick up when he attacks me a couple of minutes later when I moved to another part of the job centre with claiming to have picked up a chair then. If this had happened, of course, this is all going on when I'm talking to both to Petch and Ryan. Ryan has turned his back. God knows where Petch is, because he never even gave a statement, I don't think, in relation to this incident. But this is all complete gibberish. He claims that I picked up a chair that Ryan didn't see, so that Ryan has claimed that he's turned his back. He doesn't hear me shouting. He's a security guard that is not concerned that I'm shouting only a foot or two from him. He's turned his back entirely. And the next time he turns around, we've got our hands on each other's clothes, and didn't witness me picking up a chair and made no mention of any picking up a chair at this point. Anyway, so I was already standing up and I put both my hands up to his chest and I told him to calm down. There were a couple of other people asking him what the matter was. The security guard told him to leave, and he then started to run between the desks, stating that the security guards were trying to strangle him. So he then picked up another chair and it came towards me and brushed my leg. I thought it was going to hit me, but it didn't cause any injury to me. So I wasn't worried about it. When he was approximately 6 foot. When he did this, he was approximately 6 foot away from me. As soon as this happened, my name was called, so I went to my appointment. I had been sat down a few minutes, and I was then spoken to by police officers who tapped me on the shoulder. I told him what had happened, and they took my details. I subsequently left the centre, and the mail was something with police. He was still shouting, so they arrested him and placed him in cuffs. So he's now given testimony about them placing me in cuffs after he's left the job centre. So this is how corrupt the police are. They're even taking a witness statement from a man who, in the same sentence, has said he wasn't a witness because he had left the building. So I'm not going to read any more of that because we know it's all fabrication from what is visible on the footage. And so there's no point in going on with any more. And I've shown the relevant part of Miss Evans' statement. Of course, she's her evidence proves that everything that Walters is saying is utter fabrication. So we carry on. Indeed, we conclude with in terms of the testimony, with what would arguably be the pièce de résistance, which is the statement from the nurse, Eileen Margaret Moran, who is the nurse that took the evidence at the walk-in centre or took the medical circumstances of the security guards, Povey and Ryan. She says on a statement made the 13th of August 2009, so this is 10 days. Why she's making a statement 10 days after the incident is of course evidence of itself, because I've already been charged. So Nurse Moran says the following: I am a qualified emergency nurse practitioner and have been registered as a nurse since 1994. My qualifications are RN, ENP, DIP nursing studies. I currently work at the NHS Walk-in Centre at Broad Street, Bristol. As part of my role, I assess patients, diagnose, treat and discharge patients who attend the centre, effectively treating patients and referring them on to doctors if necessary. On Monday, the 3rd of August 2009, I was at the walk-in centre on duty when I saw two patients who presented themselves at about 5 p.m. following an investigation. So she's saying they presented themselves at 5 p.m. She doesn't actually say, it's not clear if she's presented themselves to her at 5 p.m. And of course, obviously they weren't together. So we're talking about a period of time. So let's assume, I mean, at the very least, from 5 p.m. she's starting to look at them. Usually there would be some sort of waiting period. So, we're being very loose with them by allowing her to say 5 p.m., meaning by the time she's seeing the first patient, which very bizarrely is in any event, she puts down as Keith Ryan and then crosses Keith Ryan out, although his name was Kevin Ryan, but she's crossed out Keith Ryan and put Paul Povey. So it's very confusing, but apparently now she's talking about Paul Povey, who informed me that he was employed as a security officer at a job centre, and informed me that he had injured himself at work that day following him being involved in a scuffle. Well, she says he injured himself, so that's not me injuring him. He described having been punched to the left side of his face. He informed me that he had been knocked out, that he had not been knocked out, nor did he complain of sickness, dizziness, or double vision, but he did complain of mild headache. I mean, people get mild headaches all day, every day, so how that could be attributed necessarily to me. It could be from simply lying so much, because that involves headache. I'm getting headache from reading all these fabrications out, certainly. And felt a little lightheaded and nauseous. Nauseous spelled wrong. I mean, the spelling, this is supposed to be a nurse, so I'm presuming it's been drafted by a police officer who is literally illiterate. She's a nurse and she can't even spell nauseous. But anyway, he describes lower back pain similar to a pain he suffered from previously from an old back injury, which of course he doesn't mention in his formal statement. I gave Mr. Povey a full assessment and suspected a soft tissue injury. I provided him analgesia, painkillers, and advised him to attend the hospital emergency department if his symptoms worsened. I noted bruising to his lower left eye. I detected no bone tenderness. His eye was open. Following advice, he was discharged. Kevin Ryan. Mr. Ryan described he was also a security officer and had been involved in the same incident with the same assailant, Mr. Povey. He described having punched, crossed out, been punched or slapped, he wasn't sure which, in the face, and complained of pain in the right side of his abdomen in the area of an old surgical scar. He complained of a mild headache. I completed a full assessment of Mr. Povey, and I did not note any visible head or face injuries at the time. Visible spelled V-I-S-A-B-L-E, so clearly written by a complete illiterate person. Anyway, I completed a full assessment of Mr. Povey. The tenderness to his abdomen was on his lower right side of his abdomen, adjacent to an old scar. I suspected the pain was due to soft tissue injury. Well, he's not suggesting, he made no claim that I'd hit him in his abdomen, so why that's relevant is beyond me, unless that was a separate complaint that had nothing to do with the evidence that's supposed to support the alleged assault on him by me. I prescribed, crossed out, provided analgesia and advised him to see his GP if his symptoms worsened or did not improve. Following this, he was discharged. So that is all the witness statements, bar a couple which are too tedious to read out and don't need reading out in too much detail, but because there's plenty of other evidence to go on to support this documentary. But of course, the point about the timing is that DaCosta says he took the photographs of the black eye that Mr. Ryan claimed to have received from my either hitting him or slapping him. He wasn't sure which. He claims it was about 7 p.m. So he was seen. He must have been, because he was. So if Ryan was the second patient, which Nurse Moran says was the case. If they presented, presuming it's not clear when he actually booked, the two of them were booked into the surgery per se, but clearly they're very lucky. They've got a police escort, which usually helps, and they're being treated as the victims by the police. So assuming that Nurse Moran is talking to, saying she's seen Povey first at 5 p.m., that the checkup would have taken at least 15, 20 minutes. Then she's seeing Ryan. So Ryan couldn't have concluded the examination taken by Moran until about 4:45 or 5:30 at the very earliest. Then they've got to be transported from the booking centre to the police station, where there's presumably some sort of kerfuffle before they can come straight in and take photographs. So let's just say, to be extremely generous to Nurse Moran's evidence and to the police case, and the CPS case, obviously, they were released, or they concluded the examination at about 5:30, and then within an hour and a half, where there was no visible injury to Povey's face at all, not even a slight beginning of bruising, and this is now 3 hours after the incident where I'm supposed to have hit him. So he's had 3 hours for any injury of any description to be manifest on Ryan's face. Where there's no injury about 5:30, then all of a sudden there's a fully fledged black eye that's clear enough to be photographed by PC DaCosta an hour and a half after there's been no black eye at all. And then conveniently, the photographs don't print out. And then even more conveniently, when at some point, and I don't think DaCosta's clear as to when he then checks on the digital version, and potentially only when I raised it as evidence of perverting justice and perjury as part of my defense. And then but in any event, the digital version also didn't materialize. So it is obviously as obvious to anybody that's taken account of all the other evidence I've given about these fabrications. And of course, Birchall Dick gave a statement when he said he saw injuries to both men. So there's an injury, according to Birchall Dick's evidence. And I don't want to be unfair on Miss Lucy, because I think she says the same thing. And if I can find her statement before this documentary is concluded and put online, I will see if I can find her the other part of the statement where I think she also says she witnessed an injury, but Dick certainly does. We've read his statement. So Ryan has an injury that's visible to Dick before Ryan goes off to be examined by Nurse Moran, where it entirely disappears. Then it materializes within an hour and a half. It has shown no sign for the 3 hours since the incident has occurred, between the incident happening and then Nurse Moran examining him. And then it suddenly materializes again for the officer to take photographs of it an hour and a half later. And then it too disappears in terms of the digital photographs disappearing, and for some reason not explained by DaCosta, the printouts from when the digital photographs were on the camera were unable to print out either. And usually, if you take digital photographs, you transfer the digital onto a computer or something. You don't just leave it on the camera. And of course, and then DaCosta then claims it was it wasn't even intended for evidence anyway. They were going to use that that was going to be left to CID at some later stage. And of course, DaCosta also claims to have visibly seen me punching Ryan clearly on the footage, which was one of the reasons he came to arrest me in the first place. And as we shall see now, when I read out Judge Longman's judgment. So we'll come back to other evidence from DaCosta, because DaCosta also claims that he saw me on the footage clearly hit Povey or Ryan, or one of the two. And of course, that's very odd, because there's no mention of that in Judge Longman's testimony, where it is clearly where I was saying that I'd never hit either of them. That was complete perjury. And it was claimed, as we should come to, I'm just going from memory here, but I think it was claimed that the reason why there was no hits visible on the CCTV was because both of the times I hit the security staff was when we were halfway down the ramp, and not actually in the doorway, which of course makes a complete fabrication of DaCosta's further evidence that he says he saw me on the footage hit the security guard. But just very briefly, obviously I'll give the order of events in terms of proceedings. It was claimed the trial, which was basically a kangaroo court of the most vile description. Of course, I cannot get legal representation, so I was undefended in trial. That's already a major breach of my Article 6 rights, human right to representation. And we have a Mr. Philibrand, a Philip Gillibrand, who now claims to be some sort of Christian converter or speech maker or something righteous and holy anyway. But this perjuring, lying sadist made me relive all the ordeals of the 24th of September, 24th of July, all of which I've recounted earlier on in this video. And in order, obviously, to put my side of events, that I was the victim of police corruption and CPS corruption. He found me guilty, gave me a 16-week suspended sentence, which was then activated. And if you go to my video, Judge Martin Picton Must Fall, you'll see all how that sentence was actually activated by Judge Brown, upheld by Judge Picton, and so on and so forth. But there's no point going into what happened at the magistrates' court. The unrecorded proceedings. You either get lay magistrates who don't know the first thing about the law, or you get a crony who will do anything the CPS say if the person isn't represented. You might as well be in front of. Indeed, I have been in front of a barrister who usually works for the CPS, a District Judge Morgan, I think his name was, or is. So it's completely out of Stalinist Russia. It's just complete mockery in terms of any kind of impartial interaction, and it makes a nonsense of this whole business about, we get jury trials in this country, the bedrock of democracy, blah blah blah. You can spend years in prison on small sentences, or smallish sentences, not small, but up to a year now, I think it is, that they can impose, the magistrates. You can spend years in prison without ever seeing a jury of any description. But in the case of magistrates' court, at least the one sort of concession to some sort of judicial oversight is that you can appeal any conviction of the Crown Court, of the magistrates' court, to the Crown Court, and then you get an automatic right to a retrial, where you can go through all the issues are canvassed again, all the testimony is given again, but it's all on tape proceedings, so there's no dispute about what people have actually said. And you have a supposedly experienced circuit judge who's one below a High Court judge, who's very senior, and and this is what I got. I appealed it, but of course, what I didn't know at the time, and only found out later, Judge Michael Longman is a former old boy from Albion Chambers, as was David Chidgey, who was prosecuting me at the time. So I had no idea that these two old boys were from Albion Chambers, and any suggestion of independence and integrity is for the birds. And of course, my whole point, as I point out at the beginning of this video, I'm subject to a conspiracy by Albion Chambers, or was during this period, where almost every single judge and barrister who prosecute me in these cases that are almost identical to this are from Albion Chambers. And indeed, the resident judge, and he gets the power to appoint which judges hear which cases, was himself from Albion Chambers. Judge at the time, Neil Ford, thankfully retired, as corrupt as the day is long. And of course, he was well aware of the most serious types of allegations I was making against the CPS by now, as well as the police. And therefore, the more serious the allegations from the defendant in terms of corruption and involvement of the CPS and collusion with the CPS, the more independent you want the judge to be from the barrister who's prosecuting you. But because Judge Neil Ford, the resident judge, was well aware of these serious allegations, he got the most cozy little club conspiracy to consider these matters, and of course, effectively just simply rubber stamp the magistrate's decision. Bearing in mind, I'd already done my time. I'd been served months in prison as a consequence of the suspended sentence being activated by the time I was retried. And indeed, I think I was in custody at the time I was being tried. And indeed, initially I was offered representation by a man called Gareth Graham, I think his name is. Certainly his surname Graham. I'll find out hopefully by the time this video is online. But he turned up for the day of trial, only to say that he was actually otherwise engaged, and he got another case pending, and he was going to take that case over the one that he promised to represent me on in that respect. And I just don't see the point. I've got some of the paperwork here, I think, online, but I'm not going to. Sorry, on my computer, but I'm not going to go through all the details of that. Safe to say, I decided to. I could have waited. I was in cells at the time, and Judge Longman said, you're entitled to representation. We'll try and get you someone else to represent you. I should have, played along with that, because that could have it eventually led to the case collapsing if I couldn't get representation, or certainly being stayed or delayed. But I couldn't see how I could possibly be convicted. And of course I couldn't know. I mean, Judge Longman, by all it looks, when you go in front of him, it seems a very calm and staid and very well spoken gentleman, and you expect this man is, he's called, to have some integrity and some decency, when in a matter of this nature, in terms of any trial. And I didn't know at the time that he was just an old boy from Albion Chambers, and as was David Chidgey. And of course, as I pointed out, the police already know that they've got Albion Chambers in their pockets from other cases, so that they know that the listing system will be totally rigged, that these are complete puppets. And so that indeed, it probably is filtered down also to the security staff. So they know the name Ben Gray just simply means utter and complete stitch-up. And as I say, they're just simply waiting in the wings to do their dirty work when the time comes. But I didn't know. I was still relatively wide-eyed at the time, and certainly didn't know that Longman was from Albion Chambers. From the same chambers as David Chidgey. And I thought, well, there's no possibility of my being convicted. It's just perjury after perjury. They can't possibly want this perjury and perverting justice to be canvassed in recorded open proceedings in public court. And of course, the papers, the press, which leads me to make my own publications, are completely in the pockets of the police and the CPS and the Albion Chambers henchmen. So they're also accounted for. They're not going to report. The only time they reported the details of the case was when the conviction was upheld, which included a 2-year banning order from every job centre in England and Wales. So they published that great headline with a photograph of my mug, saying, man banned from every job centre in England and Wales, beating up security guards and left, right, and centre. And of course, that's also going to be passed around to every other security guard. And so that's the interest they took in the case. They're not there to hear the evidence, to hear the actual counter allegations, or the extent to which Judge Longman is just simply just the most evil, horrible creature that you could ever imagine, forcing me to relive being trussed up and having to urinate myself, and having my injuries, scabs knocked off, and having the handcuffs put on the injuries caused by Walters, and the endless evidence of perjury and perverting justice, even just surrounding the incident of the 24th, in which Ryan was the chief architect. And then obviously all this perjury and outrage surrounding the incident on the 3rd of August. So, little did I know what I was in for when I said, no, I'll wait. I'll represent myself. I can't. I actually said, you seem like an honourable person. I'm happy to go. I'm not happy, but I'd rather be in person and get this over with. Because bearing in mind, I haven't even given instruction to Gareth Graham. He's turned up on the day of trial with all this video evidence and statements and everything, none of which I've had any interview. I've had no discussion with the lawyer. I think it was M&M solicitors. So I'll see if I can get at least the name of the solicitor involved in that. So if this is the day of trial, how am I supposed to prepare a case, given that Article 6 of the Human Rights Act says that a defendant has a right to prepare adequate time and facilities to prepare their case? Well, how can I prepare the case on the day of the trial when I'm making counter allegations, and of course the torture that having to relive all these ordeals is bad enough, let alone on the actual day of the trial in cells with some person I've never met before. All completely evil puppetry and puppeteering. And so in the context of all the evidence I've read out and all the film footage, I'll now read out Judge Longman's conclusions as to why he upheld the conviction against me for the 2 counts of common assault. Benjamin Gray appeals his 2 convictions on charges of common assault by the Bristol Magistrates Court on the 19th of February 2010. The charges arise out of an incident at Bedminster Job Centre on the 3rd of August 2009. We have heard evidence concerning what happened on that day and also some evidence about an earlier incident at the same job centre on the 24th of July 2009. In brief, the respondent's case is that as a result of the incident in July, the appellant had been banned from the job centre. When he attended there on the 3rd of August, security guards blocked his way at the entrance. During his efforts to gain entry, he assaulted two security guards, Paul Povey and Kevin Ryan, by hitting them in the face, causing in each case a black eye. When he's referring to the respondent's case, he's referring to the prosecution case. It gets very confusing because I'm, in some ways, the respondent also, especially when I judicially reviews the matter. But he means David Chidgey, his old mate from Albion Chambers, the prosecuting representative. The appellant's case is that he did not hit the security guards as alleged, and that his behaviour, including the alleged blows if proved, amounted to lawful self-defence. I mean, so right there, we've already got some evidence that DaCosta lied when he said that there was video footage of my hitting him, because if I had denied that I had hit him ever in any event, even if it was justified, then that's clear evidence I perjured myself, if not perverted justice, because under oath I've said that I never hit them. But anyways, as far as the respondents are concerned, the incident on the 24th of July was relevant by way of background only to explain how it was that the appellant came to be banned, as they say he was. Some witnesses who gave evidence in support of the charges were also present at the earlier incident, and we allowed evidence to be given in respect of the 24th of July as being relevant to the credibility of those witnesses, who include Mr. Ryan and Mrs. Lisi, the job centre manager. We also considered the evidence relating to the 24th of July in relation to Mr. Gray's contention that the case was an abusive process on which we have already ruled. We emphasise, however, that the real issue in the case is whether the appellant hit the complainants as alleged on the 3rd of August, and if so, whether he may have been acting in lawful self-defence. So what Longman has said, he's aware of the evidence that I've given in terms of the 24th of July, not only that I've given, but of the statements. He saw the statement in particular from Elizabeth Evans, who gave clear-cut evidence that she saw Walters strangling me, the injuries I've received when I've defended myself against the strangulation and injured my wrist, the clear fabrications from Ryan that he said he saw me throwing chairs around, because even Judge Longman refers to the credibility of Ryan being relevant to why. So all of that is irrelevant. The evidence that I'm the victim, the only relevance to Judge Longman is evidence that Povey and Ryan might have been injured, as sort of well down the line of my being repeatedly injured by Booker, by the arresting officer Fevin, by Walters. Any injury to me, any distress caused to the other members of the public as a result of those injuries, any perjury surrounding that resulted in my being effectively kidnapped, that's of no consequence to this Minister of Justice. The only consequence is my final response to this onslaught of glaring evidence that's not even disputed. It can't be disputed well, it wasn't disputed, but certainly that for instance, that I didn't throw the chair. There's film evidence clearly showing I didn't throw the chair, and clear evidence that I was being attacked by Walters, and so on and so forth. All of which we've covered in detail. So not only is he showing bias, he's saying he's hand in glove. He might as well be sitting behind in some room somewhere with a walkie-talkie, dictating all this evil villainy that's being meted out to me by these goons. On the first day, Petch and Ryan. On the first instance, Petch and Ryan, and then Ryan, Povey, and Dick. Anyway, let's just carry on, because he's made his position clear as day in terms of his collusion in all the villainy of the 24th of July. And of course, by making me relive it, he's torturing me. He knows full well the mental ordeal of having to relive, being trussed up, having to urinate myself, having injuries inflicted on myself, having been strangled, and having to listen to lie upon lie upon lie from Ryan in particular, is mental torture, especially as I'm doing it as a defendant. And then all he does is mention it in passing, whitewashes all those ordeals that he's made me relive. So the trial itself becomes clear-cut mental torture. That's clearly an offence for any public official to be carrying out torture on a member of the public under the Criminal Justice Act 2008, I think it is. I'll put up the statute, section 134, for any public official. So to use the trial process itself to torture me is clearly what he's done, as well as obviously colluding in all the corruption and attacks that occurred. And of course, there's child abuse, because there's no dispute. Children are being distressed by the incident on the 24th of August, as well as other people, as well as the 3rd of August, all of which is being caused by the police, collusion with the security staff, colluding with David Chidgey, colluding with Judge Longman. Anyway, in considering these matters, we've reminded ourselves of the burden and standard of proof and need to consider each charge separately. We have also reminded ourselves that it is for the respondent to prove that Mr. Gray was not acting in self-defence, and that we must consider self-defence in light of the circumstances as Mr. Gray honestly believed them to be. Also, that a person acting in the heat of the moment cannot be expected to be able to calculate with precision how much force it is necessary to use in order to defend himself. Also, that preemptive force may be lawful. All these matters which we take into account. The incident took place in or near the doorway of the job centre. This area is covered by a CCTV camera inside the job centre, and we viewed the relevant footage a number of times during the course of the evidence. We also heard evidence from staff inside the job centre, the 2 security guards who were alleged victims, a 3rd security guard, Birchall Dick, who was present being on relief duty that day, and 4 job centre managers, Ruth Lucy, Karen Rockash, Jessica Brown and Karen Smith, who saw at least part of the incident from different viewpoints within the job centre. Although we were able to view part of the alleged incident as captured by CCTV, we have borne in mind that the view of those present was, in certain regards, better than the CCTV camera's view. Well, not at all, because every single witness of even Birchall Dick, says that their view was obscured by the 2 relatively diminutive security guards in front of them, but the CCTV is clearly much clearer, because it's a bird's eye view over the shoulders of those people who claim that their views were blocked. So, you know, even the witnesses themselves contradict this lying scoundrel, Judge Longman. But anyway, we also heard evidence from a nurse Moran, who examined the complainant shortly after the incident, and of police officers responsible for Mr. Gray's arrest and interview. Mr. Gray himself gave evidence about the events of 24th of July and 3rd of August. Following the incident on the 24th of July, Ruth Lucy requested that a firm of solicitors sent to Mr. Gray a letter banning him from the job centre. The solicitors wrote a letter dated the 31st of July 2009, informing him he was banned from a number of job centres, including Bedminster, for 3 months, as from the 1st of August. At the material time, Paul Povey and Kevin Ryan had been instructed to stop Mr. Gray coming in. Mr. Gray described how they stopped Mr. Gray coming in, and he tried to barge past them. He pushed them, and they pushed him back. He said that Mr. Gray punched him in his left eye, then assaulted him by punching him in the eye. He said his eye was bruised as a result. In cross-examination, he conceded that when he made his written statement the same day, he referred to 1 punch only. He also said it was only 1 punch also when he gave evidence in the magistrate's court. So he's been given permission just to throw in an extra punch because he can't believe how corrupt these police and judges and barristers are. So he might as well go for broke. So I don't know why he didn't say I didn't punch him 50 times. He might as well have done, considering he's made up both the punches. That's certainly the extra punch, which he's added on for good measure. Anyway, when he was examined by Nurse Moran at about 5 o'clock the same day, he had bruising under his left eye. He was photographed the following day and again on the 6th of August, and a black eye as seen in those photographs. No, she doesn't say he had bruising. She just said that there was some swelling. But we'll go back to the statement in a moment. Anyway, Karen Rockash described Mr. Gray hitting Mr. Povey in the face as he, Mr. Gray, attempted to push past him. She said it looked as though he hit Mr. Povey in his eye with a fist. She saw 2 movements and believed that one made contact. Ruth Lucy described Mr. Gray lunging forward with one arm, and she could see that he was making contact with the guards. In cross-examination, she said that she knew that contact had been made because the guards were pushed back. Karen Rockash said, well, she can't know, can she? And Judge Longman must, however corrupt he is, he can't possibly be pretending that she knows something because it is inferred by somebody falling back. They might have been coming back to avoid something. They might have been come back to make it look as though I punched him. There's a difference between knowing something and having an impression that something has occurred. We know that Judge Longman, for instance, is a lying, corrupt judge because he has given evidence that he clearly knows is not true. That's based on evidence, not based on guesswork or an impression. Anyway, Karen Rockash said in evidence that she saw Mr. Gray's fist hit Mr. Povey. She was viewing from a distance of about five meters. Mr. Povey was just outside the door and she could see Mr. Gray from where she was, even though from the viewpoint of the CCTV camera, he was round the corner. Absolute gibberish. There's no... Rockash cannot see through walls. The CCTV shows exactly the panoramic view a much clearer view of what the staff from the job centre have at ground level. If something happened round the corner, the CCTV can't see it, and therefore Miss Rockash or any other witness can't see it. He's talking utter gibberish. He's pretending or claiming that Miss Rockash can see through walls. But anyway, Karen Smith described Mr. Gray trying to push past the security guards. At one point, she says she lunged at Paul Povey and punched him in the face. Well, no, Miss Smith gave evidence. I cross-questioned her about this, and she looked at the footage and she said, I thought I saw you punch him. Having looked at the footage, I saw that I didn't see that. So she contradicted herself, and yet Judge Longman ignored the fact that she conceded that she actually didn't see me punch Povey. And he even was prepared, he even gave me, ordered the transcript of that particular part of the evidence to be disclosed. It's coming up on your screen now, hopefully, if I can find it before this video goes out. So, utter fabrication. He's just going on the original evidence she gave before it was before she accepted that the evidence, the original evidence she gave was false. And ignoring the evidence in order to secure the conviction for his mate, David Chidgey from Albion Chambers. Mr. Povey had shown on the DVD holding his face, as if he had just been hit there, quite. And the audio tape of the incident, as recorded by Mr. Gray, records Mr. Povey saying, as about that point in the incident, although we have not found it possible to synchronise precisely the DVD and the audio tapes, you assaulted me, mate, right in the eye. As we have said, Nurse Moran noted an injury to Povey's face when she examined him, and we have seen photographs taken of Mr. Povey on subsequent days showing him with bruising under his eye. Mr. Gray, during his evidence, denied that he had hit Mr. Povey as alleged. Having considered all the evidence, we are sure that Mr. Gray did punch Mr. Povey in the face, at least once, causing an injury to his eye. We accept the evidence of the job centre staff, and although the view from the CCTV camera is imperfect, find that it gives some support to the evidence of the witness. In particular, it shows Mr. Povey holding his hand to the side of his face. We do not accept that he has invented this allegation, which was made first at a time when he must have considered it at least possible that what had happened was recorded by the camcorder, which Mr. Gray held throughout the incident. Well, I mean, that's utter nonsense, because just holding your cheek and saying you've assaulted me isn't evidence somebody's been assaulted. And the fact that he wouldn't lie because it was recorded that proves that he would be lying, well, that's utter nonsense, because they're lying. Judge Longman himself lies over and over and over again in his judgment. Even in order to be prosecuted for the incident on the 3rd of August, Judge Longman has already had to have included, as has David Chidgey, as have the police, have to include it in multiple fabrications from the incident on the 24th of July surrounding throwing chairs around and all the other fabrications from the witnesses there. Indeed, the amount of collusion by the police in the fabrications and the lies, as well as the violent attacks against me, including by the police themselves, would have clearly given succour to Povey to know that he can lie his head off too. He can join in the lying campaign because he knows that Ryan has already got away with major criminal violence and lies from the incident of the 24th of July. So that's another reason why Judge Longman should be going into the details of the 24th of July, which he doesn't at all. He says it's relevant, and he says he's allowed it into evidence, but then makes no further mention of it, of that evidence. So anyway, turning to the alleged assault on Mr. Ryan himself told us that Mr. Gray struck him in the face to his right eye with some force. He said that he told Mr. Gray that he'd assaulted him and said that Mr. Gray hit him in the same area, causing him a black eye and swollen eye, which came up later. Mr. Povey testified that Mr. Gray slapped Mr. Ryan across the face and then punched him. Mrs. Rockash said that she saw the appellant slapping Kevin Ryan on the side of his face several times with some force. She conceded that in her written statement to the police, she described it as a tapping. She said so hitting someone with some force is the equivalent of tapping. The whole point of tapping, it defines a blow, something that doesn't amount to a hit, or certainly hitting someone with considerable force or some force. She said that what she saw was hard enough to cause the injury which Mr. Ryan had, and that what she saw would not be visible on the CCTV because it took place round the corner. If it took place round the corner, I think that he's repeating Rockatch's evidence anyway, then she wouldn't have seen it either. How could she have seen it if it's round the corner? And we can see where she's standing. We can see where all the staff are from the CCTV that's available. At no side do they claim that they actually followed the security guards round the corner and joined in the carried on with the afternoon's entertainment at that stage. Just utter gibberish. And the CCTV proved that at no stage did they come round the corner with the security staff. Jessica Brown, who did not see the whole incident, and bearing in mind, he's ignoring the key evidence from that justified my arrest in the Costa statement, that he'd clearly seen me strike these officers, these security guards, on the footage. So in order to get around how it wasn't visible on the footage, otherwise the Judge Longman would have said it, he's already colluding in the clear-cut fabricating, the perjury, the perverting justice by making false allegations and inventing incriminating testimony from the Costa that justified my arrest to begin with. Jessica Brown, who did not see the whole incident because she was dealing with customers, described Mr. Gray barging into the security guards as he tried to get through the building. She said she saw his hand fly up in the air and Mr. Ryan's head move to the side. Mr. Ryan said, "That's the second time you've hit me." From that, she inferred that the contact had been made. She too said that the view she had was better than the CCTV. So, I mean, it is just beyond belief. I mean, Birchall Dick's claim, he was right at the front with the security guards, and he said his view was obscured and he couldn't see any blows landing because he was standing right next to, or certainly side by side, and yet this judge claims that the CCTV is less clear. And not only less clear, but of course the CCTV is impartial. It's not part of some work colleagues that have been working together for years, just as Longman has been working together with Gigi for years in the corrupt little neck of the woods in Bristol. We have regard to the audio tape and transcript. At one point, a voice referred to the transcript as that of Mr. Povey, said, "That's twice you've done that, that's assault." Mr. Gray then says, "Oh, you think you can jab me in the ribs?" Mr. Ryan says, because that's not in dispute. One thing the CCTV clearly shows is him pushing me into the ribs, into the railings, etc. Mr. Ryan said in evidence that he told Mr. Gray that Mr. Gray had assaulted him, to which Mr. Gray replied, "What, you've assaulted me by hitting me in the ribs?" We find that the transcript is wrong in attributing the remark to Mr. Povey, and that it was in fact Mr. Ryan who could be heard telling Mr. Gray that that's twice you've done that, that's assault. Different witnesses say that they saw an injury to Ryan's eye after the incident. However, when he attended the walk-in centre to be examined by Nurse Moran, he had no visible injuries. A photograph taken the next day shows him with bruising under his eye. It doesn't. The photograph doesn't prove bruising. it proves that there's something that could be bruising. It could just as easily be makeup. I mean, presumably Judge Longman has heard of, makeup, and that people who look like they have bruising in films and movies and all kinds of documentaries, etc., who don't actually have bruises. So it doesn't prove that he had a bruise. It had some mark that may have been a bruise, which mysteriously disappeared or wasn't visible, when officially examined by the nurse. In the course of his evidence, Mr. Gray told the court that he did tap Mr. Ryan lightly on the cheek in what was an instinctive response to being jabbed hard in the ribs. He maintained, however, that he did not hit Mr. Ryan as alleged, nor did he cause the injury seen in the photograph. He accepted that if this was all he did, even if that were technically capable of amounting to assault, it would not constitute the assault with which he is charged. Having considered the evidence in relation to the alleged assault on Mr. Ryan, however, we are satisfied that Mr. Gray did deliberately strike him in the face and that he did so hard enough to cause the injury which is seen in the photographs. We do not know why it was that the injury, which was visible to others, was not visible to Nurse Moran, whether it had not yet developed and the witnesses who saw it did so later. Well, I'll at least get to the end of the sentence. Or whether the initial reddening had gone before the bruising appeared later. So, I mean, he ignores the evidence certainly from Dick, and I think from Lisi, that they witnessed an injury to Ryan's eye long before he was examined by Nurse Moran. So he fails to mention it disappeared altogether by the time he was examined by Mr. Moran. And of course, we'll come on, but I don't think he mentions anything about the disappearing photographs that were originally taken of the black eye by Da Costa. Or whether the initial reddening. So we are, however, sure that the injury which Mr. Ryan undoubtedly suffered, which was visible when the photographs were taken, was not inflicted other than in the course of the incident, and that it was the result of Mr. Gray hitting him. There were no independent witnesses to the incident who gave evidence. All the witnesses were employees at the job centre, although independent witnesses were present. We do not conclude from that the police have been selective in choosing only witnesses whom they believe to be impartial, nor do we find that the job centre staff have deliberately lied in an attempt to incriminate Mr. Gray. Having seen the witnesses from the job centre, even if you ignore everything on the 3rd of August, we know that Ryan's lied about throwing chairs around because the CCTV shows that I didn't throw the chair, that I lifted it momentarily, and only because I'm being charged at by a man who's at least, 14 stone, 16 stone, 17 stone, and taller than me. So we already know that Ryan is lying about that. So he's already lied to incriminate me in respect to that incident. So he's already committed multiple serious criminal offences before we even get to the incident of the 3rd of August. Having seen the witnesses from the job centre who gave evidence and having considered their evidence carefully, along with the CCTV footage, which of course shows no striking of either of the security guards, but much violence against me from them, we are satisfied that they have sought to give an honest and accurate account of what happened and what they saw. We find, therefore, that Mr. Gray did deliberately hit both Povey and Mr. Ryan in the face, and we turn to the question of whether he may have done so in self-defence. It is Mr. Gray's case that the purported ban from the job centre was ineffective and unlawful. Since the ban was unlawful, he believed that the force used by the security guards in preventing him from entering was unlawful, and that he was therefore entitled to use force himself to effect entry. Well, and I'm not using force to effect entry. I'm using force to defend myself from the violence that's being used to prevent me getting in. That is different. Further, he maintains that the only force he used was proportionate and lawful. In support of his argument that he should not have been banned from the job centre, well, of course, again, Judge Longman's whitewashing and fabricating the reason for wanting to get into the job centre at all, which is to record the evidence of the perverting justice of the claim. And we've seen one police officer, I think it's Fevin, but I could be wrong, but you can rewind to see which officer it was, who said that there was no CCTV camera covering that area, when even the officers themselves, certainly later Chambers, the investigating officer, accepted that there was a camera there, but there was some nonsense about what the footage not being transmitted or being recorded, or it was. It's changed so many times, but there was a camera there. Let's just leave it at that. There was a camera covering the initial incident on the 24th of July, And it was to get evidence of perverting justice surrounding that camera that I wanted to get into. So I'm not just trying to get into the job centre just to prove a point, as Longman is implying. In support of his further, he maintains that the only force he used was proportionate and lawful. In support of this argument, that he could not have been banned from the job centre, he cites Article 5 in his right to liberty and security. We find that this aspect of his case is misconceived. Article 5, while protecting his right to liberty, does not confer upon him a right to go where he pleases or to enter a particular place, even one which is normally open to the public. Well, what is liberty then? It's not, liberty isn't to go into somebody's home. It's not to go into some sealed area of an office. It's not to go into a locked toilet. But if it's an area that's normally open to the public, and if I'm banned from it because of an injunction by a court order, which you can get injunctions to prevent people from going to parks, from any public area, but there's been a trial, there's been proceedings in which all the evidence has been heard, and the judge will conclude, usually in the favour of the very rich, powerful, government-connected organisation that's trying to get an injunction against somebody who probably can't even afford representation or get representation. But at least there's been some process by which an injunction has been in place, and even then you can breach the injunction if you've got a reasonable excuse under the law. But if the right to liberty isn't to go to a place that's normally open to the public and in which there's no court order in place or bail conditions in place preventing that person going, then what is the right to liberty? It's utter. By Judge Longman's own account of understanding of the right to liberty, presumably there's nothing to stop the security guards from stopping me leaving my house and walking down the street, because that's normally open to the public. So surely this judge is lying in his teeth. He's saying I don't have liberty to go where everybody else has liberty to go, without any, even if it's to get evidence to prove major attack against me and against innocent members of the public surrounding the CCTV camera where I was initially attacked by Walters. Anyway, so in asserting that the purported ban from the job centre was unlawful, Mr Gray further relied on what he described as a ruling by a district judge in other proceedings to the effect that such a ban was unlawful. During the incident, according to the audio tape which he recorded, he said, District Judge Williams in the Magistrates Court says you've got no legal right to ban me, and the District Judge in Bristol has already tried me about banning me, and you're not legally allowed to do it. That was what the District Judge in Bristol said. In the course of trial, he also made similar references. In evidence, Mr Gray referred to this as a comment made in a trial before a district judge during cross-examination of a police witness by Mr Gray. He produced a letter from a magistrates court legal advisor quoting relevant notes of evidence, which suggests that the judge remarked that a letter purporting to ban someone would not by itself be a grounds for arrest. We do not consider this an observation. If it is accurately recorded, amounts to a ruling that a ban such as the one which the respondent says applied at this time was unlawful. We do not, however, find it necessary to make any ruling as to the lawfulness or otherwise of the purported ban. Even if such a ban is unlawful, which is a question for a different court, that would not give Mr Gray the licence to use excessive or disproportionate force in seeking to gain entry when physically prevented from doing so. Well, that's obviously to turn things on its head. The issue is whether the breach of the ban, even if the ban is lawful, or indeed ignoring whether it's lawful, because the judge himself has said it's irrelevant whether it's lawful or not, the degree of force that can be used to impose the ban is lawful. So he's turning the whole principle on its head in terms of who's using force against who. And we'll come on a bit more to what the judge says. We do, however, find that it is possible that Mr Gray did genuinely believe that the ban was unlawful and that he was entitled to enter the building. When Mr Gray tried to enter the building by force, as he accepts he did, and the security guard stopped him from doing so, he was entitled to use disproportionate force in response. Well, the force that's being used that's disproportionate is by the guards keeping me from entering the job centre. I'm simply trying to walk into the job centre. The judge has said there may the whatever law is being invoked to stop me entering is not lawful. May well be the case. If the ban may not be lawful, then what possible lawful excuse do these security guards have to lay hands on me? They're touching me all over on my body without any, long before they're even alleging I've attacked them or hit them. And the judge said that's perfectly perfectly okay. Mr. Gray, I mean, I'm not committing any offence. This is a court of criminal law. As the judge says, the ban may be for another court, but this court is establishing the issue of the use of violence and to what extent it amounts to assault either way. He's saying that just the mere act of committing no offence, but simply walking to a place that I'm entitled to walk to under the criminal law, can be used with violence that may well cause injury, may well cause death if I've got a weak heart, or cause shock, may well even cause injury to somebody that's trying to get in and out of the job centre, because they're also being put in the line of fire with the violence that's going on. He's saying all the violence that's been used against me is perfectly lawful, even though I'm not doing anything except trying to breach a ban that he says potentially may not have any lawful effect at all. We have considered all the evidence, including that of Mr. Gray, of the behaviour of the security guards towards him. Ruth Lacey said that she did not instruct Mr. Ryan or Mr. Povey to use force, and they did not use force. It seems clear from viewing the CCTV, and indeed from what Mr. Ryan and Mr. Povey themselves said, that they did use force against Mr. Gray in order to keep him out of the building. So he's basically finding there, without any equivocation, that Miss Reese has lied. She must know whether or not force was used. She was standing at a ringside seat about an incident that she herself effectively orchestrated, because she has control over what the security guards are doing. They didn't want me to enter. They didn't have to use force. They just had to close the door. Clearly, me breaking into the door would have been criminal damage at the very least, and they would have had a carte blanche case against me for the force used against an inanimate object that is dividing everybody, including me, from entering the job centre. But whilst the doors are left open, it's Miss Lacey who is allowing and ordering the guards to attack me, and then she comes casually into court and in front of this crony monster Judge Longman says, I didn't, no force was used against Mr. Gray to keep him. Meanwhile, we can see on the footage the three burly security guards pushing me against railings, pushing me down slopes, involving other innocent parties in that violence. And he formally finds effectively that she's committed perjury, given evidence that she knows to be false or do not believe to be true, which is an offence that carries up to 6 years. So he's casually referring to his own collusion in that criminal offence. Mrs. Rocket said that the security guards were trying to stop Mr. Gray from coming in. They were not aggressive. Well, we can see how aggressive they were, even if I can't find the tape of Povey swearing his head off. Jessica Brown said there was no aggression from Mr. Povey and Mr. Ryan that she witnessed. Karen Smith said that the security guards were doing their job. The CCTV shows that both security guards did use force against Mr. Gray in preventing him from entering the building. So he made an absolutely collateral key finding that the force was used against me, that clearly force is aggressive. I mean, police often refer to people, certainly police in particular, refer to people being aggressive, even when they're not doing anything but even if they're raising their voice or taking a particular stance. Aggressive is used for all kinds of things which aren't even violence of any description. These people are attacking me full on, and he's referring to major perjury from Rockash and Smith in particular, who said that they weren't being aggressive at all. I mean, violent force is violence. Violence is aggression by any definition, and even Judge Longman seems to accept that before he just casually invokes it to convict me. Mr. Gray gave evidence that security guards were pushing him against the railings by the ramp which leads to the entrance. Mr. Ryan accepted that it was possible that Mr. Gray was pushed back onto the railings, and the CCTV does not suggest otherwise. What a very long-winded way of finding that I was pushed against the railings, which must be an assault. If I'm committing no offence at all, and I'm being pushed against railings, on what possible basis? The only justification for them to use that force is if I was attacking them, not from just simply wanting to go into the job centre, especially to collect evidence of the previous violent assault from Ryan. Mr. Ryan said that Mr. Gray said that Mr. Ryan put his hand in his face and was shoving him. Mr. Povey, he said, seemed to have lost the plot and was like a rabid dog, and that he had to be held back. He said that one of the two jabbed him in the ribs. Having seen all the witnesses giving evidence and having considered the CCTV footage, we are satisfied that the blows which we have found were delivered by Mr. Gray against Mr. Ryan and Povey amounted to excessive and disproportionate force over and above anything that could amount to lawful self-defence. Taking into account the circumstances as Mr. Gray believed them to be, we find that the blows in each case, and we have considered each charge separately, amounted to force which was excessive and therefore unlawful. In these circumstances, and for these reasons, we find that Mr. Gray did hit both Mr. Povey and Mr. Ryan, and this behaviour in doing so was unlawful, and accordingly these appeals against conviction are dismissed. And the final leg, as I've mentioned earlier in the video, is the judicial review application. Now, the judicial review was put before the High Court under CO 340 2012, and was dismissed by Mr Justice Silber, Stephen Silber, photo of him coming up on the screen, and he not only dismisses the application but also imposes what was called at the time what is called a general civil restraint order, which prevents me litigating in other matters going forward. I'm being accused of being a vexatious litigant, and my application is dismissed without merit. This application was brought, so he says in the first reason is observation is that it was not brought within the prescribed 3-month period. That was because I was subject to another civil restraining order, so I wasn't able to bring any proceedings, and I could only do so once the previous CPRO was discontinued. And then he goes on to, in any event, permission would have to be refused because A, the reason set out in the Crown Prosecution Service's grounds for contesting the claim, and in particular paragraphs 16 to 29 thereof, and B, the claimant had an alternative remedy available to him, namely appealing by way of case stated in respect to many of the complaints, with the consequences of permission, the consequence that permission should be granted. So the statement that he's referring to there, I think it's illegal for a judge just to refer to grounds provided by one of the parties. They have to sort of show some independence by making it clear that they've examined the evidence and finding on their behalf, but on their own sort of recognizance. The response was provided from the CPS representative, a man called Leslie Chinwezi, who's now himself a fully fledged immigration judge, and he at the time was working for the CPS, so hardly the most independent counsel you could find. Not even clear if he was even a barrister at the time, but in any event. I'll read the relevant paragraphs that the judge refers to from Mr. Chinwezi's response. So Chinwezi says, summary of the claimant's grounds. In the event that the court is prepared to consider the claimant's grounds, notwithstanding the time which has elapsed from the decision of the Crown Court, they can be summarised as follows. So, of course, I mean, bearing in mind all my allegations against Judge Longman are that he's colluded in perjury, perverting justice, torture, kidnap, endless evidence of perverting justice. The only concern, the only interest for the initial reliance of both the judge and Chinwezi is that it might be out of time. So in any event, what Chinwezi says going on, firstly, that the rehearing before Bristol Crown Court was unlawful in that H.J. Longman failed to give adequate reasons for dismissing the claimant's claim. Well, no, because I didn't make a claim. It was a fully fledged retrial. So it's a defence statement and defence case, defence pleading, and appeal proceeding, but it wasn't a claim. This is a claim. The claim that what's been dealt with by Judge Silber and Chinwezi is a claim. What happened in the Crown Court was a criminal trial. In his ruling, Judge Longman did not refer to the claimant's claim of self-defence as set out in Section 76 of the Criminal Justice Act, it's Criminal Justice and Immigration Act. H.J. Longman failed to deal with the non-defendant bad character evidence under Section 100 of 2003. Oh, well, that's all just gibberish. He's just making up. He's making up his own version of my grounds. I'm not going to read them out because it's quite obvious what they are from this documentary. But obviously, no grounds are going to make any possible sense at all unless, no defence or response. Let's call it a response, which is what Jinweizi is providing, is going to make any sense without the actual original grounds being cited. Secondly, the substance of the prosecution evidence was contradictory both between the witnesses and the CCTV of the incident, and the judge, in his reasons, had ignored or whitewashed examples of perjury. Lack of reasons. It is accepted that on dismissal of the appeal against conviction, the appellant is entitled to a clear statement as to the issues which had to be resolved and the basis of which it had resolved them. Wakeman v. DPP 2007 RTR 45 DC. It is submitted that an 8-page ruling consisting of 44 paragraphs. The Crown Court gave detailed reasons for refusing the claimant's appeal. These included summarising the claimant's case, highlighting the issue to be resolved, including the claimant's lack of self-defence, summarising the evidence of 3 job centre staff that saw the claimant either lunging or punching Paul Povey, as well as CCTV, medical, victims' evidence, explaining why the court came to the conclusion that the claimant had punched Mr Povey, summarising the evidence of the victim and the witness in relation to the assault on Mr Ryan, including the CCTV and audio evidence. Paragraphs 24 to 26 and 43. It is submitted that the Crown Court gave sufficient cogent reasons for refusing the claimant's appeal. As stated, the Crown Court considered the claimant's claim of self-defence and the appropriate elements. There is no requirement the court needs to refer explicitly to the statutory provisions set out in Section 76 of the Criminal Justice and Immigration Act. Non-defendant's bad character is not a key ground of my defence, so I'm not going to bother with that. Contradictions in the prosecution case. Well, that's contradictions is obviously another word for perjury. If there's obviously some contradictions can take place where it's just an innocent misunderstanding or misreading of events or mishearing, etc. But we've got basic, clear-cut perjury starting with the incident on the 24th of July. We don't even have to bother with the incident 3rd of August, all of which only occurred because of police and CPS collusion in the attacks and violence and perjury and perverting justice surrounding the incident on the 24th of July. So this is what this would have been cited in my grounds, but as I say, I'm not going to waste time with it. The claimant cites the following examples of contradictory evidence. In the magistrate's court, Kevin Ryan said the claimant hit him once. In the Crown Court, he said he hit him twice. Well, that's clearly must be perjury. You don't suddenly, the magistrate's court trial happened a year after the incident, 19th of February 2010. So it happened, getting on for 9-10 months after the incident happened. So if he didn't remember it, but after the incident, when he gave the statement to the police originally, and when he gave testimony under oath in the magistrate's court, he's unlikely suddenly to remember a second hit that wasn't witnessed by anybody. If you actually look at the witness statements that I read out, if you remember them, H.H. Longman is in his judgment incorrectly stated that Karen Smith, a job centre employee, had said that the claimant had punched Kevin Ryan in the face, whereas under cross-examination, Miss Smith had admitted it looked like the claimant had punched Mr. Ryan in the face. Well, no, she admitted that she didn't see him hit him in the face. That's the key point. That the way it's worded there is so confusing as to not be clear that what she actually said, that she clearly and unequivocally did not see me hit Ryan in the face, as she gave in a sworn statement. Glaring evidence of perjury that would clearly form a case that should be put before a jury as in terms of perverting justice and giving false evidence, because she claimed to have had a ringside view. I mean, Judge Longman repeatedly states that the witnesses had a better view than the camera. I mean, utter lunacy, considering that the camera, is impartial and was of a bird's eye position over the shoulders of those who, many of whom claimed they couldn't see anything or couldn't see clearly what was going on because of the being blocked by people in front of them. But in any event, she clearly, and the point is that even when she contradicted her statement and made it clear that she did not see me punch either security guard, Judge Longman said that she did. He ignored the clear fact and that's the key point, that he relied on her initial evidence and her, which was echoing her witness testimony that she had seen me punch one of the guards, and then openly admitted that she got it wrong and that she didn't see it, and that judge didn't hear the bit where she said, "Oh, actually, no, I didn't see him hit him," and just carried on with the original evidence, thus making a point. Apart from anything, not only is Judge Longman lying in his crooked teeth, but he's clearly making a nonsense of the whole point of a trial. What is the point of cross-questioning trial? You get the witness to backtrack, who's already not impartial because she's a colleague of the person that she's reporting against, and then she corrects her evidence and clarifies it, and then the judge ignores all the correction and lies in his teeth to cover it up. That's obviously making all that money that's spent on the point of the trial. Why didn't Judge Longman just simply make his judgment and not have the trial? It would have been much cheaper, much easier, and done the same thing. Given he's going to say whatever's going to allow him to convict an innocent man who's actually the victim of violent attack himself. Nurse Moran saw no visible injury to Kevin Ryan's face at 5 p.m. on the day of the incident, yet Birchall Dick and PC DaCosta claimed to have seen an injury to Kevin Ryan's face before he was seen by Nurse Moran, the claimant. Sorry. Let's see, I'll read this again to see if it even makes any actual grammatical sense. Bearing in mind, this guy's a lawyer. It's one thing for some illiterate police officer to get his talk absolute nonsense in a witness statement. This is a trained lawyer that's supposed to be, effectively advising, acting as Judge Silber, considering he's not making any decisions about the case at all. He's handing it over, as he says in his formal decision. Nurse Moran saw no visible injury to Kevin Ryan's face at 5 p.m. on the day of the incident. Yet Birchall, he didn't look at Ryan at 5 p.m. It was much later than that because she'd already examined Povey. So he's already, it's very hard to make any progress with these decisions and comments because even when you get one sentence into them, they're already having to be proven as false. So it was much later than 5 p.m. because she'd already, assuming, and it's not even clear from Moran's statement when they actually presented themselves to the medical building in the first place. It wasn't until after she had examined Povey, so it must have been much later than 5 p.m. when she examined Ryan. Yet Birchall Dick and PC DaCosta claimed to have seen an injury to Kevin Ryan's face before he was seen by Nurse Moran, this claimant responded to. So that's grammatically meaningless. I don't know what he means by the claimant respond to. It's actually a complete sentence because there's no full stop after Moran, so it's meaningless. And this is the judge. These are the findings that Judge Silber is relying on. Presumably, if Judge Silber had made the finding, he would at least made grammatical sense. But I don't claim that DaCosta claimed to have seen the injury to Ryan's face before he was seen by Nurse Moran. At no stage do I say that's complete lie. I accept that DaCosta saw Ryan after she was examined, but the point is that Nurse Moran examined Ryan. The point is how soon after Nurse Moran said there was no injury to DaCosta claiming to have seen a fully fledged injury. And of course, completely whitewashed is the whole scandal surrounding the photograph that didn't print out, and then the digital photographs themselves disappeared, which was so convenient to the fact that there had been no injury seen by a witness. And of course, Birchall Dick did claim to have seen an injury many hours before Ryan was seen by Moran. So it is an injury that has disappeared, that has appeared according to at least one witness, then disappeared according to the professional nurse, then reappeared again according to a police officer who claims that but there was a fault both with the printing out of the initial digital photographs and then the digital photographs themselves vanished in a puff of smoke. And the DeCosta, I think, I seem to recall, was given an award, or was very closely connected to investigating paedophilia photographs and some digital surrounding that. So this is an officer is then going to go on and involve himself with other, dealing with other cases and other photographs, including to do with child abuse. God help us all. But anyway, in her evidence before the court, Karen Rockash said she saw the claimant slapping Kevin Ryan's face, but in her witness statement, she said the claimant tapped Ryan's face. Well, there is something of a contradiction between hitting with force and tapping, which I obviously don't need to spell out. Neither the judge nor PC DeCosta were able to identify where on the CCTV the claimant was shown striking Kevin Ryan or Paul Povey's face. Well, as I recall from the footage from the trial, DeCosta simply randomly stopped me at a particular point on the entire CCTV and said, "That's where, that's what I'm referring to in my sworn witness statement, where I saw you hit one of the guards, which is one of the reasons why I came to arrest you for that I had, sufficient independent evidence." So I'm not making that claim. I'm pointing out that Judge Longman himself makes it clear that he doesn't see any hitting in the entire footage that he's watched. Any reference to me being seen to have hit one of the guards by the other job centre staff is explained away because I'm round the corner, not only out of view of the CCTV camera, which is why it's not shown on the camera, but bizarrely, obviously out of view of the job centre staff also, which means they couldn't have seen it because they couldn't have seen round corners unless they had a stethoscope or an X-ray machine. Or they're superhuman. Again, just simple garbled nonsense, nothing to do with the evidence that I'm relying on to support my judicial review that I've been convicted an innocent man, and there's been multiple evidence of perjury and perverting justice. And of course, the general civil restraint order is to prevent me providing further evidence of the same kind of criminality that this corrupt Judge Silber is colluding in. It is submitted that in a fast-moving incident, it is natural that witnesses will see the same event from different perspectives and there will be some contradiction. Well, no, because it doesn't. I mean, whatever fast-moving events has occurred, all that I'm relying my judicial review on is in the very, very slow-moving events of the trial proceedings, in which every single witness is in an ample time to look at the footage. So clearly, the fast-moving events, that's why, one of the reasons why CCTV cameras exist, so that the recording can be slowed down, it can be stilled, the still footage. And of course, Chinweizi has ignored all my allegations surrounding the 24th of July anyway, which is completely key. Even Judge Longman accepts grudgingly that what happened on the 24th of July was relevant to the case. And I've relied on all the clear evidence of corruption surrounding that, which is ignored. So, but the fast-moving nature of the incident itself has nothing to do with what happened at the trial. When either the CCTV shows me hitting, clearly shows where I've hit one of the guards, or it doesn't. If there's no CCTV, not a shred of evidence in the CCTV that's viewed repeatedly by the judge that shows me hitting any of the guards, then the officer could not have seen me hit the guards. He's lied about that in the footage so that he can then arrest me and kidnap an innocent person. And DeCosta's already hand in glove with my being kidnapped on the 24th of July, as I hopefully hardly need to keep repeating. None of the contradictions pointed out by the claimant rendered the decision of the Crown Court so unreasonable that a reasonable tribunal could not have come to the same decision. For instance, the claimant admits that in interview tapping Kevin Ryan in the face, which undermines his contention that the CCTV did not show him striking anyone. Well, no, I touched him. I don't think I admit to tapping. I admit to touching his face as a sort of, as an immediate response to him hitting me in the ribs. And that's as far as my admission went. Judge Longman has himself found, so we don't even need to worry about what Chinweizi is going to lie about, because Judge Longman has already said if the evidence that Mr. Gray gave, if that was what he did, then it could not have caused the injury that's being complained of. There's clearly touching or tapping someone even, and that the tapping was actually Rockash, or one of the other witnesses that claimed to have seen tapping. But it's got nothing to do whatsoever with the finding that I'd hit him, which I denied doing, and which Judge Longman accepted, that my evidence that I accepted that I did touch him at some point. Obviously, I touched him, but the specific reaching out, it doesn't look like a hit. It would have been shown, it would have been relied on, was where it looked like a hit. Mrs. Smith, or Miss Smith, recounting her evidence that she had seen me hit him. If it looked like a hit, then she would have seen me do it. She would have admitted to it. She wouldn't have recounted her evidence in her sworn statement if the footage showed some sort of hitting. The whole point of, obviously, the judiciary of the oversight judge, which is Judge Silber, supposed to be Judge Silber, not a CPS crony that he's relying on to do his judging for him before Chinwezi himself gets promoted to be another liar in a wig. But the point is he's supposed to be independently looking at the evidence. If he's given that Judge Silber has handed that role over to him, Chinwezi should have looked at the footage and said, well, here, this is where it looks like Mr. Gray's hitting Ryan. But of course, reaching out to touch someone, the whole point about tapping is obviously it comes with a much less force than a punch. In order to cause the injury, it has to be fast-moving punch. It can't be just reaching out and touching and tapping somebody. In and of itself, and then, I mean, the point that I've made that DaCosta had lied to say that there was evidence on the footage that he had seen me punch, not seen me tap. He'd seen me punch, not seen something that looked like it could have been a punch, not seen somewhere that the security guard had staggered back, but he couldn't see the front view, which would have obviously been referred to by Judge Longman when finding me guilty of the punches. He would have referred to, I saw on the footage the same thing that DaCosta saw, end of story. And that my allegation was that footage didn't show anything that was a punch, because I never punched them, and most of the staff, if not all of them, at some point alleged that it happened around the corner, which was why it didn't show on the footage. The judge says that repeatedly with different witnesses. So DaCosta, and the complaint was that DaCosta therefore made it up. Even if I did punch them, according to the witnesses, it was not seen on the footage because either of us is obscured or it happened round the corner. So the point about DaCosta lying was that, and this lunatic, this absolute corrupt, lying degenerate, Chinwezi, refers to simply the fact that DaCosta said he saw the punch is somehow evidence that therefore it must exist on the footage. If it existed on the footage, then Chinwezi himself could have said at time where it was on the timestamp, provided a photograph to the court, said on at 3.3, I can see what DaCosta could see, and then somehow, and that he would still have to explain why Judge Longman couldn't see it. And Judge Longman is lying in his teeth over and over again. He lies to say that, if he's going to lie to say that Smith has seen me punch one of the complainants, when she, under oath, and the Judge Longman even provided the transcript where she recants that, then clearly there was nothing on the footage that showed anything like a punch to one of the guards. And that was my complaint anyway. So in any event, Chinwezi is simply lying and making up the ground, which was or simply just inverting so clearly, if I'm accusing DaCosta of lying because the footage shows that at no time does the footage show me actually punching one of the guards, then clearly just simply repeating the lie that DaCosta has told is not evidence, is not a lie. The footage is what proves it's a lie or not. That's why we have CCTV cameras, to prevent endless court cases over who did what based on verbal allegations from people who have different interests in making those allegations. Again, the court can fully consider the issue of the lack of injury noted by Nurse Moran to Kevin Ryan. Well, for a start, I mean, Chinweiz is already fabricated who saw what at what stage, or what was alleged to have taken place at what stage, in this great sort of hodgepodge of lies and further lies and more lies from Chinweiz. But in any event, the court didn't fully consider it, because obviously it needed to be seen in the light of the digital photographs that were taken, to be relied on in question, but yet weren't evidence, but then couldn't print out anyway. Apparently, in a very high-tech modern police station such as Broadbury Road, they couldn't find a printer to print out some a couple of digital photographs prior to questioning. Photographs that couldn't print out, and then the digital images themselves disappeared, which was very convenient, considering that what Nurse Moran had said only an hour before, that there were no injuries on Ryan at all. The court didn't consider it. So even that is a lie. Lies about more lies about more lies. But in any event, the final remark from Chinweiz, or final couple of paragraphs. In conclusion, the Crown Court referred the evidence of the prosecution witnesses to that of the claimant. The evidence of the claimant's guilt was overwhelming and supported by corroborative witnesses, and in the case of Mr Povey, medical evidence and CCTV footage. The court is respectfully asked to refuse the claimant permission. Well, there's no details about the law, about the force that was used, about the accepted that force was used, the degree of violence that even Judge Longman accepted was used, the fact that Lisi perjured herself about saying that no force was used when even Judge Longman found that there was. So just a lot of just complete whitewash and lies and fabrication from Chinweiz, rubber stamped by this evil crook, who thankfully no longer sits on the bench, but should never have been on the bench to begin with, Judge Silber, Judge Stephen Silber. So there again, ladies and gentlemen, just another one of many, unfortunately, dozens of that I have made or have to make or will make at newsworthy publications. This is the judiciary in this country. This is the state of law and order in this country. Utter tin pot, banana republic, dictatorship type collusion by the judges in stitching up members of the public, in convicting not only innocent members of the public, viewers, but members of the public that are clearly themselves victims of major criminal violence and corruption.